To start with, I would like to introduce our session chairs, Professor Varun Jindal and Professor Mamta Biswal. So, Professor Varun Jindal is from IMB. He did his PhD from IIM Calcutta. His research interests are in corporate finance and mergers and acquisitions, and he teaches corporate finance for MBA and PhD students in IMB. Professor Mamta Biswal is a professor at Gujarat National Law University, and she has a PhD in law, and she is also the head of the Center for Corporate and Insolvency Law at GNLA. And the research interests are corporate law, insolvency and bankruptcy law, and international trade and business law. So we have four presenters in this session. So the timeline for the presenters is that they will have 20 minutes to present, followed by 5 minutes of Q&A. And so that's the house rules. And without any delay, I'll just ask the first presenter, Mr. Debaranjan, to share his slides. Mr. Debaranjan is a master's student at Melbourne Law School, and he is presenting a paper titled Evaluation of the Guidelines for Communication and Cooperation between the Adjudicating Authority in India and the Foreign Court in Cross-Border Insolvency Proceedings, a Comparative Perspective. So, Mr. Debaranjan, the floor is yours.
Thank you very much. I'll just start sharing my screen. A very good morning, I would say, to the chairs, my fellow panelists, and the members of the audience. Basically, this particular paper that we have written outlines the evaluation of guidelines for communication and cooperation between adjudicating authority in India and foreign court from a comparative perspective. And this paper has been jointly written by myself and Dr. Andrew Godwin at Melbourne Law School. Moving on to the objectives behind writing this paper, principally the main objective behind writing this paper was that India goes on to enact the guidelines on cooperation and communication between adjudicating authority and the foreign court. We thought it would be prudent that we examine the experience of other foreign jurisdictions in that regard, and also in relation to insolvency protocol. In the process, our research paper has also evaluated what contributes to the success of an insolvency protocol. And thereafter, finally, in our paper, we have analyzed India's draft guidelines on communication and cooperation. Now, the aspect of communication and cooperation between different authorities can be confined to only state actors. And the guidelines that have been drafted by the Insolvency Law Committee dealing with cooperation and communication is only restricted to state actors, that is the adjudicating authority and the foreign courts. At the same time, communication and cooperation can also take place between non-state actors like foreign representative and Indian resolution professional. However, it is very important that before we develop on this research paper further, a distinction is being drawn between cooperation and communication restricted to state actors like the adjudicating authority and foreign courts and non-state actors. Because, as I will explain later in the paper, this distinction is very important and has to be very well appreciated in deciding cross-border insolvency. Moving on to the first part of my paper, which tries to analyze the purpose of cooperation and communication in cross-border insolvency. Some scholars have suggested that it is to cooperation and communication in cross-border insolvency that the insolvency paradigm moves from the principle of territorialism to the principle of modified universalism. When the Indian adjudicating authority and foreign courts will have cooperation and communication between them. It will foster an environment for communication and cooperation between the Indian resolution professional and its foreign representative. Because insolvency protocols between non-state actors, that is the Indian representative, the Indian resolution professional and the foreign representative, is a privately negotiated agreement which ultimately has to be approved by the courts in different jurisdictions. Therefore, if there is an environment in which the adjudicating authority and the foreign courts are regularly cooperating and communicating with each other, fosters an environment where an insolvency protocol between the Indian resolution professional and a foreign representative is very easy to visualize, and thereafter it can be easily approved subsequently by the adjudicating authority and the courts and the foreign courts. Apart from this very important purpose, our research has shown two other very important purposes. While we have listed down 6 of such purposes, for the paucity of time, I will only develop on 2 further purposes. The first, drawing from the experience in United States, we have found that communication and cooperation between adjudicating authority and foreign courts become very important when there is an application seeking that a foreign proceeding is denied recognition as a foreign main proceeding on the ground of public policy. Communication and cooperation between courts is also important when an adjudicating authority is faced with a proposal for approval of a resolution plan from a foreign jurisdiction. And thirdly, it is also very important when there is an application in a cross-border proceeding seeking the remittal of assets from one particular jurisdiction to a foreign jurisdiction. In this context, I want to mention the landmark case of Hanjin Shipping. What we found in Hanjin Shipping was that through cross-border communication and cooperation, a very efficient judicial outcome was reached by the courts. Now, coming to the facts of Hanjin Shipping in its heydays was one of the largest container shipping industries in the world. Unfortunately, it had entered into rehabilitation proceedings in South Korea. Subsequently, the South Korean rehabilitation proceedings were recognized as foreign main proceedings in the United States. Now, the corporate debtor wanted to remit some of its assets, sell some of its assets in the United States and remit the proceeds to South Korea, from where the global distribution assets could take place. However, the US creditors in this particular case had immediately intervened and objected to such remittal of assets because they thought that by remitting the assets outside the jurisdiction of the United States, their priority will not be preserved and they may be treated prejudicially. However, in this case, we found that the United States, taking a very pragmatic approach, after listening to the US creditors, entered into a direct communication and dialogue with its counterpart in South Korea, trying to understand the insolvency regime in South Korea. And only when his fears that there would not be any kind of inequality meted out to the creditors in the United States were acknowledged, that the US bankruptcy judge had indeed ordered remittal of the proceeds from the sale of the US to South Korea. The other aspect where our research found that communication and cooperation becomes very important is in way of enabling courts to join or influence and in the process promote positive legal outcomes. Now, what do I mean by this? Now, in a cross-border insolvency proceeding, there's a requirement of reimagining the role of adjudicating authority. In a cross-border insolvency proceeding, the adjudicating authority is not a mere adjudicator. Its role is that of a facilitator of right and just outcomes for all the creditors and in the process for the stakeholders. Now, how does it do so? It does so by engaging in cooperation and communication with its foreign counterpart, and in the process establishing judicial networks. If I can say, in a sense, judicial diplomatic networks by which it jockeys for influence and in the process reaches a just outcome for all the creditors and all the stakeholders in the process. Moving on to the next part of my presentation, where basically I discuss on the aspect of insolvency protocols that are negotiated between the resolution professional and a foreign representative. I have already previously highlighted the role that the adjudicating authority plays in fostering the environment for negotiation of such protocols. And what I found in my research is that such legal insolvency protocols can be classified into two legal conceptualization. The first legal conceptualization sees it as a court-created treaty. The reason being that although the insolvency protocol is privately negotiated between the insolvency representative, it ultimately has to be sanctioned and approved by the courts. So some scholars see this phenomena as court-created. However, majority of the scholars view an insolvency protocol more in the nature of a contract, and therefore any breaches in the insolvency protocol often has provision for appropriate contractual remedies. Now, going forward, although this is not the topic of my presentation, going forward, our research anticipates that insolvency protocols between insolvency professional and foreign representative might actually have dispute resolution clauses where such breaches of its terms or provisions may be properly adjudicated. Now, moving on to the next part of our research, which I think is very important, where we have basically analyzed the factors that contribute to the success of the insolvency protocols. Now, we have found various factors that contribute to the success, but for the purposes of the present I will focus on what we have found, that if the insolvency protocol is very flexible in its structure, it's not too prescriptive, it has greater acceptability among its participants. We also found that if the particular insolvency protocol preserves judicial independence, there is chances of its success. Now, what do I mean by judicial independence? The insolvency protocol must be structured in a way that it does not impinge into the substantive aspects of judicial making and only regulate aspects which do not fall within the judicial decision making. In this aspect, it also needs to promote procedural efficiency. It may often be that various competing jurisdictions have differences in the substantive laws. However, what the insolvency protocol must do is have appropriate procedures in place so that these kinds of substantive divergences in the laws can be properly treated through appropriate procedures. While in our paper we have explored many themes on this issue, I want to take reference of three particular instances. The first thing by which procedural efficiency can be preserved is by responsible allocation of judicial roles and duties. What do I mean by that? there are well-known norms under private international law under which courts of different forums can be allocated different roles and responsibilities. For instance, in regard to applications which question the validity of certain actions, the insolvency protocols prescribe that the court having jurisdiction over the assets will be the correct forum to adjudicate such disputes. In relation to questions regarding claims against debtors, the insolvency protocol may prescribe that it is the court having jurisdiction over the place where the debtor resides that will be the appropriate forum to decide such issue. Another thing that we found greatly improves procedural efficiency through insolvency.
5 more minutes.
Yes, sure. Yeah, protocols is aspect of having provision in the protocol where the parties agree that each of the parties in their respective jurisdictions will actually submit similar or close to similar resolution plans. This way, the substantive legal issues, divergences in the different jurisdictions can be ironed out. Now, I will now quickly go on to the analysis of India's draft guidelines on communication and cooperation. What we find in our analysis is that in the draft guidelines, the adjudicating authority is the main driver of the process. The adjudicating authority, as at the earliest opportune circumstance, has to endeavor to enter into some sort of a protocol for cooperation and communication with a foreign court. What we also found that it can only be procedural in nature. And this brings me to my first part of my presentation, where I said that it is important that we draw a distinction between protocols, between adjudicating authority and a foreign court, and a protocol between an insolvency professional and a foreign representative. The protocol between adjudicating authority and a foreign court must be, as per the guidelines, only procedural in nature. However, when we look at the insolvency protocols between a resolution professional and a foreign representative, because it has to involve the entire cross-border insolvency process, although not desirable, it may often get into territory of substantive law. For instance, in the Jet Airways protocol, we find that the parties in the protocol itself agreed that the center of main interest will be, which to my knowledge is a substantive issue of insolvency law, and would not be permissible if the protocol between an Indian resolution professional and a foreign representative would have to be strictly procedural in nature. There are other aspects that we have analyzed in our paper, but due to paucity of time, I will not go into it. I would directly skip to the aspect of the key takeaways. Now, key takeaways, what we find is that, as I have mentioned earlier, is that there has to be a reimagination of the role of adjudicating authority in cross-border insolvency proceeding. The adjudicating authority in such instances cannot be a mere adjudicator, but has to play a more active and interventionist role, where it has to promote just judicial outcomes through what we have called in our paper judicial dialogue, judicial networks, and judicial diplomacy. We also found that it is very important that the independence of the judiciary must be preserved. The adjudicating authority in India, while communicating and coordinating with its foreign counterpart, cannot lose sight of the fact that in the end, it has to reach its decision by independent judicial decision making. The perception that the general public should not perceive that the judiciary in India is being by what it is communicating with its foreign counterpart. Finally, I would conclude by saying that the success of communication and cooperation is contingent on the aspect of predictability and consistency of outcome in the entire Indian insolvency ecosystem. Because only if uh, yes, I just take one. Because only if an authority or a foreign representative for that matter benefit is actually communicating and cooperating with the Indian adjudicating authority or Indian resolution professional, will they come forward to cooperate and communicate. And they will only see benefit if there is some sort of a predictability and consistency of outcome in India's entire cross-border insolvency regime. Therefore, in our paper, we have advocated for of a sort of rule of law in the entire Indian corporate insolvency ecosystem, so that it promotes a sense of predictability and consistency, and in the process fosters cross-border cooperation and communication. With these thoughts, I end my presentation. I welcome any questions, thoughts, and comments from the chair, the panelists, and the other members of the audience. Thank you.
Thank you, Devaranjan. I request the participants to have asked questions, if any, to the presenter. You have 5 minutes for this.
Yeah, so if you have any questions, there is a microphone on your desks. So please press the button and it will become green and then you can speak. Otherwise, those who are online won't be able to hear you out.
And those who are online can post questions in the chat box. I'll just ask the questions formally on your behalf, Devaranjan.
Hello, Devaranjan. This is Application Work. Was requesting to listen to your paper, and it's very tricky sort of situation that protocols have to be identified between these two countries, or they can be multi-country, which is expected. So now, as far as your paper is concerned, I just want to know from you if you have considered any particular protocol which has been entered into between two countries, and also the role of the state-augmented judicial insurance network in these aspects.
Right. Thank you, Professor Garg, for your questions. In course of our analysis, we have considered some of the leading protocols that different countries or different insolvency practitioners have entered into. And what we have found is that the basic takeaways that our paper presents are actually derived out of those particular frameworks. And what we have found is that most of these protocols are following a particular structure, and there have been a certain provisions which have now become set in stone in terms of how these insolvency protocols are drafted. But most important we have seen is that what contributes to their success is, as I have mentioned in my presentation, is that while it has to align different divergences in substantive law, it also at the same time has to be flexible and not be too prescriptive in its operation. And we have in our research also considered, as you rightly mentioned, GIN guidelines, the guidelines. Actually, the Indian guidelines are modeled along the GIN guidelines, which very minor modifications. And one of the modifications that we found is that what the Indian guidelines actually say is that that the guidelines after being adopted by the adjudicating authority and the foreign courts, they may be amended and modified unilaterally without by just giving a sort of a notice to its foreign counterpart, which we thought is a bit harsh because it kind of hampers the confidence with which a foreign adjudicating authority or a foreign court engages with the Indian adjudicating authority. Because if a foreign adjudicating authority sees that the Indian courts can actually uh, amend, modify, or terminate if call for communication and cooperation, they may not feel very comfortable in entering into one.
Mr. Devranjan, I am S. Raut, I am
Yes.
Joint Director in MCA. What I understand
Right.
is that your paper is based on October 2018 IELTS report, isn't it? That was
Right,
the last
yes.
one published. Okay. Now you talk about the protocol. Do you think that we
Right.
should have some template protocol in the legislation as and when cross-border comes?
I would not feel so because the point is, as I keep on harping, is that there has to be a sort of flexibility in terms of how protocols must be negotiated. And depending on the various circumstances of a particular case, appreciating the unique circumstances of particular case, I think they should be considered. However, as I mentioned, that certain provisions have kind of crystallized as norms in terms of protocol. For instance, what our research has shown that there was one insolvency protocol framed in a US bankruptcy case called N001, and that has now become more of a protocol which is now being presented in all cases, and standard protection orders are being granted on basis of that. So maybe some guidelines can be given as to what the contents of the protocol between resolution profession and a foreign representative. But I would not go to the extent of saying that they be documented in the form of a legislation, because I think by that it will become too prescriptive.
Thank you.
Thank you. Thank you for the question.
Mr. Devranjan, first of all, I congratulate you for this wonderful presentation. But I have two queries. The draft guideline,
Thank you.
you refer to a draft guidelines. What is that guideline?
Yes, so this draft guideline are the guidelines which are framed by the Insolvency Law Committee in its report on the rules on cross-border insolvency. So there, in the form of a schedule, they have framed the draft guidelines on how the Indian adjudicating authority and the foreign court should communicate and cooperate with one another.
Are you talking about this Insolvency Law Committee which recommended to adopt the ancestral model law, the chapter Z,
Yes,
proposed chapter Z?
yes,
Okay.
yes.
So
So,
you have
madam,
gone through the guidelines?
yes, I have.
And whether that draft guidelines which recommended for adoption of ancestral model, is it by the main committee or Mr. K.P. Krishnan committee? Which guideline?
Madam, after the Insolvency Law Committee actually came up with its report recommending India to enact a cross-border insolvency law, there was subsequently another report on the rules pertaining to cross-border insolvency.
Okay, I
In
got
that
it. But whether, because two, three points I have that you refer to private international law, then ancestral
Right.
model law that recommend chapter Z. So have you seen
Yes.
there that whether that particular education and communication between the adjudicating authorities?
Yes, so madam, in the
Another point you may answer jointly. Why did you refer to private
yes,
international law?
yes, yes. So I will just try to answer your question sequentially. So the draft law as recommended by the Insolvency Law Committee, which is draft part Z, it has provisions for cooperation and communication between the adjudicating authority and the foreign court. Now, those provisions, in order to give effect, some guidelines were needed, and these guidelines have now been framed by or now been suggested by the Insolvency Rules Committee, which kind of amends, or I would say, not a right word, it kind of supplements those provisions in draft part Z as to how the adjudicating authority and the foreign court must communicate and cooperate with each other. And coming to a question on the issue of private international law, I mentioned the issue of private international law in the context that when we were looking at as to what contributes to the success of insolvency protocols, we found that in a lot of occasions, there is substantive divergences between the legal regimes in India and the other foreign jurisdictions. And the parties may enter into a deadlock. So we saw that certain procedural innovations can be made in the insolvency protocol so that such deadlocks can be resolved easily. And one of the ways we found that such deadlocks can be resolved is by efficient, I'll say, allocation of judicial responsibility. Parties in the insolvency protocol itself agree that which particular forum is the right forum for the kind of disputes before it. And this we have proposed can be done through established principles of private international law.
Thank you.
Thank you. So I think we can go ahead with the second presentation.
Yogaranjan, I would request you to stop sharing so that the second presenter can also share.
Yes, thank you. Yes, I've stopped sharing.
So our next presenter is Bharti Singh. She is a PhD student at IIM Ahmedabad in the finance and accounting area. Bharti, I request you to share your screen. You have 20 minutes for the presentation, and also please press F5 on your computer so that your presentation can be shared in the presentation mode. Thank you. You can proceed. While you do that, her paper is titled Examining Earnings Management of Firms Filing for Insolvency, Empirical Evidence from Bankruptcy Law for Pro Creditor.
Good afternoon to all of you. Can you see my screen?
Yeah.
So can I go ahead? Hello, can you hear my voice? Can I go ahead?
Yes, we can hear you. Please.
Can you? Yeah, thank you. So first of all, good afternoon to all of you. I am thankful for the organizers, the Insolvency and Bankruptcy Board of India, and along with IIM Bangalore for giving me the opportunity to present my work as someone. My name is Bharti Singh and I am a PhD candidate in finance and accounting area. This present work is one of the essays of my thesis. Essays of one of my thesis, and the present work titles as Examining Earnings Management of Firms Filing for Insolvency, Empirical Evidence from a Pro-Creditor Insolvency Regime. So first of all, I would like to highlight a crucial difference between a pro-creditor versus a pro-debtor insolvency regime. So in case of a pro-debtor insolvency regime, for which the US is a leading example, what actually happens when the firm is admitted for the bankruptcy, the management has the exclusive right to submit a proposal for the reorganization plan. But in case of a pro-creditor insolvency regime, for which India is the leading example, the management has to relinquish control under Section 29 AC of the IBC, and hence explicitly is removed for further for further insolvency process of the company. Hence, in this study, I try to examine what would be the behavior of the management of a firm for in country like India, where the management has to give up the control once the firm has admitted to the country, once the firm has admitted to the insolvency. For that, I have relied on the definition of the earnings management as given by the Healy 1985. So, where the earnings management has been defined as earning management as altering the financial performance of the company in order to mislead the investors or the stakeholders. Thus, the prior literary evidence related to the earnings management has done mostly in the context of the US, and the literary evidence were found to be very mixed, that there are certain reasons that why the managers would actually show a better picture than the true performance of the company, for which the evidence is related to the income increasing earnings management. So the literature has the literature has pointed out some of the reasons that what could be the motivation of the managers for showing a better performance of the company than actually it is. For example, the Gilson and Wetsupen's 1993 showed that the management would like to do that because they want to avoid showing a pre-tax loss, and as a result they want to avoid a intervention by the board of directors, and hence they would try to show a better picture of the company. And another reason provided by Defond and Zimbabwe 1994 showed that the management would like to do so because they want to avoid a debt covenant violation, and when there is a debt covenant violation, it actually puts further cost to the company. Fisher et al. 2019 suggested that the management would like to show a better performance of the company in order to convince creditors of a successful reorganization plan. But there are other literary evidence which put that the management can also possibly show a worse performance of the company than actually it is, and why they would do so. The Saleh and Ahmed 2005 reported that because a worse performance of the company could influence private debt negotiation, but while Cheretu et al. 2007 put that the management would do so in order to avoid litigations. And most of these studies have been done mostly in the context of the US, which is an example of a pro-debtor insolvency regime. And that, as a result, it gives a very motivation to us to examine earnings management in the context of India, which is an example of a pro-creditor insolvency regime. Thus, I put my first hypothesis as the bankrupt firms engaged in income decreasing earnings management the bankrupt firms engage in income increasing earnings management in prior years before they are admitted to the bankruptcy. Sorry for the typo, it is income increasing earnings management in prior years before they are admitted to the bankruptcy. Why I am putting that? Because in case of the India, where the management has to relinquish control, I am arguing that the management would try to do everything to avoid firms getting into the bankruptcy because they have to relinquish control. In a similar line, I actually propose my second hypothesis that the financially distressed firms are engaged in income increasing earnings management in prior years before being classified as financially distressed. So there is a difference between the bankrupt firms, and I am here making a difference between a bankrupt firm and the financially distressed firm. What exactly I am saying, that the financially distressed firm which ultimately were not admitted to the bankruptcy. So the present study has also done in the context of the financially distressed firm which ultimately were not admitted to the bankruptcy, and then I have compared the result that whether the earnings management had differed for the firm which finally were admitted to the bankruptcy versus the financially distressed firm which were not admitted to the bankruptcy. For carrying out the study, for accounting related data, I have relied on the CMI ProS database, and the period of the study is the 1st April 2016 to the 31st March 2020. It would be known to most of the participants that the IBC came in 28th May 2016. So, but the period of study, just for the sake of the financial year, I have taken 1st April 2016. And for the list of the firms which were admitted for the insolvency proceeding, I have relied on the IBBI website and I have extracted data from the list which was provided by the IBBI. After the data what we have received, I did do the stages of the data elimination. So the number of firms found in the data set which was provided by the IBBI, there were 1,833 firms, and out of which, for which I relied the accounting related data from the CMI ProS database, I did find only the results related to the 677. There was a mapping I had done on the basis of the corporate identification number, CIN number, and out of the 677 for which I extracted only the public listed firms, I did find 89 firms. And since I am examining I am conducting the study by looking at their financial performance in the past 6 years, I did find only the 31 firms for which there is a availability of the data in their past 6 years as well. So overall, the number of firms in the present study is 31 and the firm year is 31 into 6. So this is the for examining the hypothesis. This is the pooled OLS model I have used. So what exactly the main so this is the here the treatment firm I have defined, the firm which have finally went into the insolvency or the firm which went bankrupt, and there are other explanatory variables. DAC is actually the discretionary accruals, which is a proxy for the computation of the earnings management. So what exactly the present equation does suggest that the earnings management in the current year period of a firm I is actually influenced by the earnings management in their prior year period, and this earnings management I have lagged till the prior 6 years. So and also I have put the interaction variable treatment control with their earnings management in the earlier period. What exactly the overall equation is suggesting that if the firm is getting indication that they are moving towards the bankruptcy, then how their earnings management, how what would be the direction of the earnings management? Would they like to show a better picture to the stakeholders of the company, or would they like to show a downward direction of the performance of the financial performance of the company? So this is the result for the firms which ultimately went bankrupt. Here the main thing I would like to show is this particular detreatment control into absolute value of the discretionary approval. It actually shows that the overall the earnings management in the 2 years before the bankruptcy, there has been an increase in the earnings management. And when this particular variable is read with the sign of this, we show that the management actually engages in the downward direction of the earnings management, which actually contradicts my hypothesis, where I did suggest that the management would actually show a better picture of the financial performance of the company. But here in case of India, what my empirical evidence showed that the management at least 2 years before the bankruptcy show a poor performance of the company than it actually is. But there are other cases as well where their discretion, but there are other areas where the discretion can be applied and which cannot be come under the legal angle, like the provision for the bad debt. The management actually engages in the management actually engages in the they actually accounts for more provision for the bad debts. And for the second hypothesis, where I checked whether the financially distressed firms which were finally not admitted to the bankruptcy did did they try to show a better true picture? Did they try to show a better performance of the company so that they would not be getting they would not be admitted to the bankruptcy? But even in the case of the financially distressed firm, I did find that there also the management engages in the income decreasing earnings management. The reason for is that in both the cases, whether the firm was financially distressed and the firms which were financially distressed and ultimately went into the bankruptcy, the financial health of the firm deteriorated to such an extent that there is no scope left for doing an upward earnings management. And the most possible reason that why the management does so, that they show a lesser performance of the company than it actually is, because they want to avoid the litigation. And this is supported by the increase in provision for the bad debts, because there is something which is actually there is a less chance of getting come under the litigation, and there the discretion can be applied. There we did find evidence that the management increase in provision for the bad debts. And the results found in the study could be the result found in the study could be representative of those countries which having a pro-creditor bankruptcy regime. The earlier studies have done in the context of the US only. This is the first study which is, as per the best of my knowledge, has been done in the context of the India, which is the example of the pro-creditor bankruptcy regime. So this is for all. Please ask the question.
Thank you, Bharti. Just ask everyone to pose
Yeah.
the question.
Hmm.
Thank you, Bharti. This is Varun.
Yeah.
So essentially, I think one suggestion I have for you, you have been arguing that there is no study in the Indian context, but there is a recent Gopalan paper in contemporary accounting research. Gopalan and others, they document that firms engage in income decreasing earnings management, and that is prior to the enactment of IBC. So I think you should refer to that paper. That is one. The second suggestion I have is, I think your sample period starts in the year 2016.
Yes.
And you are taking 6 years prior to the
Bankruptcy. The
so
IBC.
Yes, prior to that. So which means that if there is a firm which was admitted in the year 2016, so then IBC will have no relation 6 years prior to the enactment of that. Getting my point, in the sense.
I'm actually, yeah, I am getting the point. So you are saying that so suppose a firm was admitted to the 1st October 2016, and I am actually taking the prior years as a 2010 till from the financial years for which I am taking into account would be starting from the 2010 or 2011. So would the firm would have the fear of would the firm would have the fear of engaging in increasing earnings management or income decreasing earnings management? Is that would the IBC play a role in the firms engaging in the earnings management? Is that what you want to say?
Yeah, especially because you are saying that the regime has been pro-creditor friendly, right, after the enactment of IBC.
Yeah.
So that argument may not hold. That's what my point is. Anyways, you can think over, I think, and see.
Yeah, but the thing is that what exactly you're saying is correct, but there before the IBC there was the Sarfasi Act, and Sarfasi also did show that they are pro-creditor, but it actually didn't play it out that the creditor would actually not benefited by the Sarfasi. But what you are saying is correct, that whether the IBC admitted to the IBC will play a role in the firms getting engaged in earnings management. I will actually put as a comment or footnote. Your concern is actually valid.
Thank you. Any other questions?
afternoon, Bharti. It's a interesting presentation, and I'm happy that I have learned a new coining of a word for the conventional word called window dressing. I'm happy about that. Number one. Number two, when you say earnings management, are you concerned about top line or bottom line? I mean, is it profit before tax level or at the turnover booking level? Okay. And this
Sir,
sequential question for this is, if it is the earnings management at turnover level, obviously there is an element called value addition. See, for example, a steel company will have a lot of, or an edible oil company for that matter, will have a 90% as material cost. Will have a little left to the value addition. He is leaving very little surplus towards the profit before tax. Entire thing. So the top line is highly misleading. A 300 crore kind of a turnover company might have only 30 crores to meet its expenditure. The case would be reversed if it is an engineering company. So my question to you is that, have you taken earnings management definition is of pertaining to top line or bottom line, number one. Number two, in the very small sampling that you have taken, have you considered any industry specific parameters, or you have put all the companies into one basket? One pharma, one steel, one cement, all those things are coming into one basket with reference to a theorem or proving the hypothesis?
So, the first question you did ask about whether I did consider the top line or bottom line, top line or versus the bottom line for the window dressing. Sir, the thing is that for capturing the earnings management, it is actually the standard definition that I have picked up from the literature. This is a very well cited papers of modified Jones model 1995, and another is from the 1991 paper. So the way the earnings management is calculated, it actually takes into account both the top line as well as the bottom line. It takes into account of the revenue of the firm as well as the because the revenue of the firm and in between the cost, as you did point out, will going to impact the profit of the firm. So the earnings, so it actually the way the earnings management is calculated, it takes both the things, the top line as well as the bottom line. So here I haven't devised a way of computing earnings management. The literature did suggest that both the top line and as well as the bottom line is taken into account while computing the earnings management. The second is that what you did say that this is a very small sample size. Yes, it is, because of the 31 firms, the finally which have been examined in this study, and I did say that 186 firms here, and I did actually. Yes, I did control for getting all these results that I am showing in the present screen. I did control for the industry industry fixed effect, which I have captured using the national identification code. So I guess that accounts for whether some firm is belonging to the pharmaceutical or the edible oil or the other companies that which you did suggest. Yes, out of the 31 firm, it is actually in the econometric model itself, I did control for the industry fixed effect. But yes, you are actually yes, the small sample size is a sort of a concern, and I can't actually help with that. Sir, did I anyway help you with my answer?
Yeah. I got. I could understand about the approach you have adopted.
Yeah.
But my suggestion is, the in Indian context, when you are trying to do any study in the Indian context, it's purely my personal view. The earnings is highly misleading. I mean, when I say earnings, I only relate to that of the top line, okay, turnover. So you have to consider the factor of value added, which means material. I mean, the turnover minus at least the material cost component that goes into the bringing the input into respect to output. If you take out the material cost and make analysis, then any theorem would be universal across all the kinds of industries. It could be edible oil industry or steel industry. That's what my point. Good job, Bharati. Thank you.
Yes, yes, yes. Hmm.
Sorry, there's no mic. Hi, Bharti. You have done a wonderful job.
Yes, sir.
As sir rightly pointed out, Martin paper. Please
Yeah.
go through that paper, Gopalan and Martin paper. They also found that same thing, downward earning management. So, what I can infer from your finding, there is no impact of IBC at all. Because same thing. So, whatever people are claiming that IBC has brought a lot of changes, nothing is happening. And second thing.
No.
So,
Yes, please go ahead. Please go ahead.
Second thing, when
No,
you
please
are
go.
controlling for industry sales effect in econometric model, right? You have just 30. You don't think that heterogeneity will be wiped out if there are less number of industry. Let's say you only industry and you are controlling for industry. So,
Yeah.
my last question is related to your treatment. I think you have created treatment group, right? So how you created the treatment
Control.
group? With a bankrupt form, you cannot it's very difficult in my view to create a control form because no form you can match directly with your bankrupt form. So I think if you follow the Gopalan paper, probably that can help you out.
So now I actually, first of all, thanks for all your 3 questions. Thanks for interest in this present study. So for the Gopalan paper, yes, I haven't actually seen, I mean, the way you are saying that it is similar to my findings. I have to actually check it out, that how similar it is. But in a way, I'm not saying anything like that IBC is not effective at all. What I am saying that the management, that what I have actually shown a different picture related to the management, that where the management has to give up the control. So what exactly in a common people would actually think that, so what we actually think that if the management has to give up the control, they would try everything not to avoid giving up the control. So as a result, we would think that the management would engage in the income increasing earnings management, would try to show a good picture of the firm. But what exactly the empirical evidence which I found in the study, that the management engages in the income decreasing, which is to avoid the litigation. And if I talk about if the management avoids the litigation, then in a way the IBC is sort of effective. But here I'm not talking about whether the IBC is effective or not. What exactly I'm trying to show in a pro-creditor insolvency regime like that of India. Your second question was related to, yes, I have a very small sample, 31, and if I have 2 industries, then how I am controlling for the heterogeneity. In this present work, I didn't actually show the sample distribution by industry, where there were more than 2 industries in my study. But yes, your concerns is valid. There are more than 2 industries in the study, and that's why I was able to afford the industry size fixed effect in this present econometric model. And your third question was related to that, how I did get a control firm for the treatment firm, because not all firms could be because for the bankrupt firm there I could not find an exact matching sort of thing. Yes, the concern is valid, that yes, how I control firm could look like a bankrupt firm. Yes, the concern is valid, but there is a literature, there are the literature that they did actually able, they did put that how they have matched with the treatment firm. So the various ways are, for the control firm I have find the covariates at total assets, book to market ratios, and first 3 digits of the NIC code. This is what have been done in the literature which I have cited in my present work, and this is how I actually did in my present study. But your concern is valid in the practical sense, that bankrupt firms could not be matched with the control firm, but the literature does in this particular manner, and which is what I did also. Any further question? Did I able to answer the question concern? Mm-hmm.
How relevant are they to Indian corporate law practice? Number two is that you spoke about listed entity 31. How
Mm-hmm.
will you come up with this listed entity as per the SEBI ICA regulation? Compliances are very strict. Whether your data is really correct or not. Number three, that when IBC is concerned, the earning management connection IBC can be triggered when default is occurred. Without any default in repayment, you cannot trigger IBC plus CIMP. So how this data and the study will be relevant to the Indian company law practice and also to IBC? Because IBC nowhere speaks about distress in the sense section 7 or 9 or 10. Everywhere unless the default is not occurred, you cannot trigger IBC. So if a company is also financially distressed but no financial creditor or no operational creditor of the company itself, they could file, IBC cannot be triggered. So my just one observation, no comment, no question, that how relevant are those US study to Indian government practice and the listed entity whether the data is correct, because you won't get it when you get such things. SEBI will intervene or MC will intervene in unlisted company. How openly one can show that the companies are showing this decreasing earning or increasing
Earnings management.
Yes, yes. So I don't know because you was the master there, but this is my observation. Because MC, you see so many cases, even small non-compliance, MC intervenes, SEBI intervenes. How can such data you can show that companies are showing such low income or higher income? That is my observation.
So,
I think we don't have time. Sorry.
so
I'm so sorry actually. I don't think we have time and we have overshot time. So I think if you want
I actually would like, I would actually like to, if you suggest, I will take 1 minute of my time to wrap up my.
please be prepared.
Mm, So, actually, whatever the concern that the person has raised related to the data, I've actually not done something with the data. It is actually available on the IBB website of 30 CIRP yielding resolution and CIRP yielding liquidation. It is available on the IBBI website. And when I did combine both the list, I did got 1,833 data sets. And for which I did find the accounting related data from the CMI first database. I did find only 677. Regarding the public listed firms, it is which the firms are either listed on the which the firms are listed on the Bombay Stock Exchange, and I did find only 89 of them. And out of 89, how many of them have the past 6 years of data? So it is not something I have done anything with the data. It is it is there, the data itself. One could actually do on your.
We are running shortage of time. My suggest my
So,
observation is not about IPBI data. It is about the study that companies they show low income 2 years prior to bankruptcy that point. So maybe you can. I am Professor Mamta Viswar from Gujarat National Law University. You can send email to me in case, because this is my observation. To what extent the
Okay.
study is connected to IBC. I'm not talking about IBC data, how many CIRP petitions are filed in India or how many liquidations, how many companies. That is a very correct data. My point is about this income management, and you spoke about lower and higher that point. So maybe you can see, we can communicate through email because we are running such
Okay.
time. Thank you.
Okay.
Thank you.
Okay. Thank you. Thank you.
Thank you, ma'am.
Thank you.
Akansha Chadha, she is a PhD student at IIM Indore, and her paper is titled Managerial Ability, Probability of Bankruptcy and Intensity of Flow. Over to you. You have 20 minutes. Yeah, you can share.
First of all, good afternoon, everybody. I hope I'm audible. I'm just running Good afternoon, everybody. First of all, I'd like to take this opportunity to thank IBBI for giving me this opportunity to present my work. So I would just like to first of all just give a disclaimer that this is just a preliminary study and a working paper, and I'm just trying to see what are the different levels of managerial ability. So how managerial ability levels influence the probability of bankruptcy. So yesterday we had a very enlightening session with Professor Vig, who was talking about the probability of default vis-a-vis the actual default. So here IBBI data has given us the opportunity to study the actual default rather than the probability that the firm will default. So it's not the imminent default that we're talking about, it's the actual level of default. So firstly, I'll just explain. The data that we are taking from IBBI, it mentions all the different firms who have announced that they have either gone into a restructuring or they have gone into liquidation, or some firms may also have withdrawn. So we take all of the cases and not only one single case. All of the data is considered. So first, what is the objective of the study? The objective is to study bankruptcy. Why bankruptcy? Because there are real costs associated with bankruptcy. Bankruptcy is time consuming. It's costly for all the parties involved, not just for the creditors, but also for the firms, for the debtors. But another point that actually prompts the study is bankruptcy actually spills over to the top management. They lose their careers, they have reputation concerns, and so managers may wish to avoid bankruptcy because of that. So the prior literature has mostly focused on the prediction of bankruptcy using publicly available information. So that's the imminent default that we were talking about, vis-a-vis the actual default probability. So IBC 2016, it provides a streamlined method to deal with the corporate debtors who have defaulted. There's a time-bound resolution, and there is also a supervised liquidation by insolvency professionals, and it provides a setting. Now it's interesting setting to study the behavioral determinants of firm distress, whether some certain firms are more likely to be in a distress versus others. So we talk about managerial ability in this context. We hope first the probability that managers drive their firms to the desired direction. It comes from the upper echelons theory, which suggests that top management is a strategic driver of firm performance, and so therefore poor judgment and low managerial skills causes firm failure. So this is the first ideology that says. But the other may also be that managers are actually unfairly blamed for being the reason for distress, where they may actually not be responsible. So high ability managers, they're aware of the personal costs and the cost to the firm that may arise due to corporate bankruptcy, and they may wish to avoid such events. And so in the literature, we've seen that high managerial ability is associated with lower financial constraints, higher credit ratings, more availability to debt. So they generally are part of firms who have lower financial constraints. However, it may also be that high ability managers maximize the wealth of the shareholders at the expense of the debt holders. So there are two different points that we're talking about. In this case, it could be that managers may also resort to strategic default because they want to increase the benefits to the shareholders at the cost of the debt holders, and so therefore the aim of the study is to understand whether high ability managers or high managerial ability impacts the probability that a firm may go into bankruptcy. Similarly, we're talking about the intensity of claims. Now, when a firm enters into bankruptcy, so there's an amount of claims that the firm is liable against for the creditors. So that's the amount of claims that the firm has, and so we are trying to see whether managerial ability will be associated with the intensity of claims. How much are the claims that are liable against the firm? So high ability managers are seen to have a greater risk-taking tendency. So they want to maximize the value of the firm. They want to maximize, they want to undertake greater risks. So they may actually manipulate the debtors to increase their incentive allocation. So they want to increase their benefits at the expense of the firm or at the expense of the creditor. So they also manipulate their debtors to increase their incentive allocation. Also, during times of crisis, like we had the previous study, that managers wish to hide the state of the firm, so which results in poor accrual quality. So this was I think the study in the previous study that Ms. Bharti suggested. So that's again the case with managers. And because of the lower transparency, so it could be in her study that there is a lower accrual qualities observed. Because of that, the creditors may feel the need to take prompt action because they see that there is opacity in the firm balance sheets, there are earnings management is taking place, so they may wish to take prompt action, they may want to file for bankruptcy because they see that the opacity of the firm is increasing. So when the amounts of default are small, when they see that the amounts of default are small, the creditors may want to take action because then they can get their money. If the amount of credit, if the amount of default is larger, then they will not get any money against the firm. But if the amounts are small, they may wish to immediately file for a bankruptcy. And so in that case, we can hypothesize that high ability manager is negatively associated with the intensity of claim of the creditors. So I think the first important question that everybody wants to know is what is managerial ability? So generally, managerial ability is unobservable. We cannot see how much ability is there. So in the prior literature, we just come back to the setting later. So in the prior literature, we have seen different elements or different sorts of indicators or proxy measures as the measures of managerial ability. So historically, pay premiums or stock options of the managers have been viewed as an indication of their ability because high ability managers, they say that are paid more, a person who is valued more has more pay. However, it may also be that remuneration may represent the manager's power instead of the manager ability and the manager's ability to control the board. The second measure which has been used in prior literature is firm performance related measures. So they say that if a firm performs better, then the manager must be more able. But again, the issue with this measure is it is corrupted by outside influences. It may be, there may be some factors which may be outside of the control of the managers, and so therefore this measure may also not be very appropriate. Then there's one more measure which is actually appropriate, which suggests that individual ability can be measured when we isolate managers, when they shift across firms, we can track the managers and see their performance and see their fixed effects and what are the specific effects of that manager on firm A versus firm B, and then we can say that this is the effect of the manager. But the problem with this measure is also that it can only be ascertained for managers that switch firms. So if the manager is constant in a firm, then we cannot track that person and compute their fixed effects. So to bypass all of these problems, all of these issues, I use a managerial ability measure which is measured using a two-step process. So the first process, it's measured using the process based of Demerjen et al., but with a few modifications. Basically, this is the topic of my thesis, which how to measure managerial ability. So in the first step, I measure managerial ability using a firm efficiency measure. So any firm that is on the highest production possibility frontier would be more efficient. So we map the best practice firm and then we measure the distance that each firm is from the frontier. So if there is a production possibility frontier, the firm on the frontier is most efficient, that is 1, and the firm which is lower, so we calculate the distance, the inefficiency component we subtract from the highest efficiency component. So in this way, many different firms can have different combinations of inputs and outputs, and they can still be efficient. So we don't need to have the same weights for each output, each input. So here we use the DEA technique, the data envelopment analysis, to measure the multidimensionality component of inputs. So here sales is the dependent variable, or sales is the output, whereas we have different levels of inputs, that is the cost of goods sold, the selling administrative expensive, property, plant and equipment, all the inputs that go into making the firm efficient, they are at the input level, the others are at the output level. And I use a slacks based method. So herein we also map the slacks. So efficiency is whatever is not efficient will also have a slack. So we also include the slacks and to measure firm efficiency. And then after the firm efficiency component is derived, we use a second step to purge out all the firm specific influences. So any factors which are beyond the control of the manager are excluded from this measure, and whatever remains is a managerial ability measure. So I think just to summarize, and I'm not sure if it got too technical somehow. So just to summarize, managerial ability is the ability of the manager to contribute to firm efficiency, excluding all the influences that may be outside their control. So the research setting, in this I am trying to see the sample period from FY 2017 to 23, because that is the period of the data from the bankruptcy IBBI. And I am including a 64,476 firm year observation. This is a unbalanced panel, in which I include the dependent variable is actually the probability of bankruptcy. This variable is a dummy variable. It takes the form of 1 or 0. So 1 if a firm is associated with a bankruptcy related event, and it is 0 otherwise. So in the data we have 9123 announcements, of which again Ms. Bharti had pointed out that there were lots of data problems. So we could not map a lot of firms. And finally 698 announcements were matched with the financial variables and all the variables that were needed for the study. So in this 698 observations are the ones which are associated with the bankruptcy event, and the rest are not. And for modeling, I modeled the probability of bankruptcy as a function of the MA score, the score which we arrived from the previous study, which I explained, managerial ability. And then I also use industry dummies as well as year dummies to control for the industry specific as well as the time specific heterogeneity. So here we can see the descriptive statistics. So again, in our sample, we have around 1.1% of the firms which have suffered a bankruptcy-related event, and maximum bankruptcies actually have been seen in FY 2020. So I think as the regime is experiencing subsequent alterations and subsequent changes, more and more people are coming forward. The number of bankruptcies, number of associated events have been increasing. So that's the observation. And finally, we can see the results that there is a negative association. So I use a Tobit regression because it's a 0 and 1 dummy variable which I'm regressing as a dependent variable. And we can see that managerial ability is associated with a lower probability of bankruptcy. Like in the previous study, because it is the creditor-oriented regime, that is the management loses control of the firm. So management does not want that to happen. So a high ability manager ensures that this does not happen. So in this, we are kind of subsequently dividing the results in managerial ability, high versus low managerial ability. So we see that low managerial ability is associated with greater probability of bankruptcy, whereas high managerial ability is not so much. And finally, with the intensity of the claims also, we see the same association that like we hypothesized that if the high ability managers are associated with more opacity of the firm, the creditors see signals in advance and they wish to get their money as soon as possible, and so they file a bankruptcy associated event. And so that is what we are seeing, that high ability managers are associated with the lower intensity of claims as well. So the contribution, finally, this paper adds to bankruptcy literature by understanding the role of managers as a determining factor in the bankruptcy related events. So this setting, the IBBI setting, the data gives us a unique opportunity to identify and study actual probability, actual bankruptcy events vis-a-vis the imminent bankruptcy that are there. The paper also adds to the literature that uses managerial personality, like optimism and overconfidence, as the determinants of bankruptcy of firms, and not just managerial personality. We say that ability is also a factor that contributes to bankruptcy-related events. And so the paper also derives the insights from the novel data being provided by the IBBI, and special thanks to that, the data that this paper could have been done. So I think I'll just finally. So any questions and suggestions?
So I have one question in case nobody else has. So yes, so my question is, do you differentiate between professional managers vis-a-vis promoter managers? Because those could be very different, right?
Okay.
Because professional managers will worry more about their career concerns
Right.
than promoter managers.
Okay.
So perhaps if you distinguish, I think
Okay.
that could be helpful.
Okay.
Any other questions? Yeah, please go ahead.
So your job is wonderful, like what you have done, a lot of insight even I got. I think up to some extent what you're trying to propose, it has been already examined, not in context of India, boarding sinking ship, one paper in Journal of Finance.
Sorry, which paper?
Boarding sinking ship, which talks about this.
Okay, yes,
Okay.
yes. Yeah.
Okay, so from my understanding, look, whatever time period which you have taken, it is also considering COVID.
Yes.
So by construction, whenever such phenomena like pandemic happens, firm go in higher distress.
Definitely.
Probability of default already high.
Definitely.
So how are you taking care of that thing? And second thing, like your sample, let's assume you have got 600 or 700 firm, and other will be zero, right?
Right.
Will be assigning.
Right.
So how can you say that these two firms will be almost equal at par?
Okay.
Otherwise, I think, in my view, maybe I'm wrong. My view, that is sample selection bias. So how are you addressing this?
Okay, so I'll try to answer. So yes, I think I have seen one or two studies in the US context, but with different variables, not with managerial ability. So I have seen different, yes, and so actually that is a good point that I should include maybe a COVID-related variable in my control variables. So I think that's a good point. Thank you for that. And what was the second?
My question is sample selection bias.
Sample selection, okay. So yeah, actually, so I have studied some literature on the sample selection bias, and actually the sample selection bias does not result in here. Why? Because the firms are not really opting themselves into the bankruptcy process, and the number, if the number of the variable, let's say 0 and 1, if it's biased, like let's say it's not biased, it's skewed, right? It's highly skewed towards 0. It's because majority of the firms are not filing for bankruptcy and they are not distressed, right? So if that does not affect or that does not alter the results very much, I think. So I can actually let me see if there are any other studies which have done anything related to that. But I think, in my personal opinion, and I've read some other studies also, so I think that should not alter the relationship very much. It should not, because it's not a selection bias per se. I'm taking all of the sample, all of the firms, and of which I'm taking I'm including listed as well as unlisted firms. So that's again not a problem, I think. So we can have this discussion, take this outside also. I think if have I answered your question? Okay. Okay.
Professional managers, maybe that young generation, their attitude to take more of risk
Right.
ability.
Correct.
Promoter managers, mostly of experienced people, and let it be a private whatever it may be. The risk ability will be not that much. And the amount of risk that people of adverse character is also there.
Okay.
Because of that, there is a business, development also, there is a consequence, up downs, we are happening.
Correct.
Sir, we could be explain what is professional management exactly. That is more
Okay.
context of professional management.
So I think professional would be like an outsider. So professional manager would be like the CEO that comes from outside rather than a promoter manager. That means the person who's inside the family business, the person who is handling the affairs. So like Mr. Ambani's son comes in, and and he's a CEO. So then he is a promoter manager. Whereas somebody like Mr. Tata appoints Cyrus Mistry or somebody else from outside, that's a professional CEO or professional manager. So I think that is the distinction that Sir is talking about, if I'm correct. And yes, that's a very good point that they do have different career considerations, and professional managers behave very differently from the promoter managers. And yes, I take that point into consideration. I will do subsequent study on that.
Madam, one small question. Is the managerial ability and it will be useful when before going to the bankruptcy? Okay, after bankruptcy, the managerial ability means all the managers and directors has been suspended. And what is the implication of the managerial ability after admitting into the bankruptcy?
Right, so I think there should be no impact. Like in the previous paper also, like we had this presentation that because the management loses control of the entire process after the IB, so after this process, the manager is not in control. The creditors will propose a solution, or whether they want to go for bankruptcy or. So I think it should not affect who the manager is or whatever. Once the process has entered into bankruptcy, I think it's outside their control. So I think it should not be relevant. Okay. Okay. So these are the basic. Yes. So this is this is the variable. The dependent variable is whether a firm will go into bankruptcy or not. So all the firms which have actually entered into bankruptcy after, so it's the data is from 2017 onwards only. So let's say there are 500 or 600 firms, out of which let's say 20 of them have gone into bankruptcy, have filed for a bankruptcy related event, whereas the others have not in that particular. So in this particular period, there are firms which have gone for bankruptcy, which have not gone for bankruptcy. So we are just trying to see if managerial ability is one of the factors that influences whether this firm which is going into bankruptcy will go into bankruptcy or not. So this is the primary objective. Then we also use control variables. Yes, I included all of the firms, out of which there are some firms which have filed for bankruptcy and some which have not. So I'm just dividing the two into 0 and 1. Right. Yes. So I've included all of the cases. So basically it's like I have taken the data, any firm that has made an announcement that they have been associated with any event. Let's say they have gone into a yielding process, they have withdrawn, even after, what are the outcomes I'm not considering. I'm only considering whatever firms have announced. There is a public announcement system that, firm, let's say I'm a firm, I announce that I am going for a bankruptcy. Yes, so there is a public announcement, right? Right, and then it goes on the website of the firm also. Right. No, the company will announce on their website that there is an initiation of a proceeding against the firm. So that goes on their website also. So they have to mandatorily report that on their website also. So there's an announcement, and there's so the firms that have announced that they have been, there has been initiation of a proceeding against them in respect to either a liquidation, in respect of either and in the end if they have withdrawn the resolution, whatever is the outs. Yes, all the firms. Yes, all the firms who have actually any event associated with the bankruptcy. So anything which have where an initiation of proceeding has undertaken. Yeah, so we're saying that if a firm has more able managers, then that because the managers take better decisions for their firms, and they are associated with, let's say, more public debt access, they have more opportunities for growth, so they do not have that situation arising for their firms. So high ability managers will not see an event associated. So if the manager is not high ability, if a manager does not know what the laws are, what the situation is happening, and so they push their firms into bankruptcy by performing poorly. So the firms which perform poorly, because the managers are low ability, they will be more likely to go for a bankruptcy. That is what the studies suggested. So that's not related to actually this. I'm sorry, that's not clear. Yeah, so actually I was saying that earlier, managerial pay or the amount of money that a manager is getting was a measure of managerial ability. But it is not true. So I'm trying to say that is not the case. Manager's salary may be an indication that the manager has power over the board, and that is why they are being paid more. So this measure is not an accurate measure, and I am proposing my own measure of managerial ability, which I had explained in the previous slides, like these slides, that how I am measuring managerial ability instead of the previous literature that has measured managerial. So this is a new measure which is being proposed of managerial ability.
Thank you, Aksha. Nice presentation.
I'm sorry if it was not very clear. I'm really sorry for that.
Time for increasing limits, and we should look at why you are raising the organization for lending.
Yes, that has been done. That
is what the school is ultimately.
yes, exactly. That if you see the managerial ability, then they are actually getting lower rates, they have lower risk profiles, so they're getting, and they have better credit ratings. So this is what this is kind of saying. Thank you.
The MSMEs have been important as it is said to be economic powerhouse of the country. It provides livelihood to over 110 million people and contributes over 30% to India's GDP. A revision in the definition of MSMEs have been carried out in the recent Atmanirbhar Bharat, bringing more units under its purview. The contribution towards all India GDP is 30%, and the contribution in all India export during financial year 2020 is 49.7%, and the employment provided is 110 million people. But there are certain challenges which are faced. The unique challenges, as the promoters are relatively new, and it is more focused upon the local market or local resources, and the organizations have been formed mostly on propriety, and the scalability is also an issue. This is the recent definition where the distinction between manufacturing and service industry has been done away with. There are two criteria: investment in P&M, plant and machinery or equipment, and the criteria 2, which is turnover based. It is micro, small and medium, as we were hearing in the morning itself, should not exceed 1 crore rupees, or the turnover should not exceed 5 crore rupees. Then multiple of 10 for the small and multiple of 50 for the medium. So it goes as 10 crore and 50 crore rupees for plant and machinery or equipment, and in case of turnover, it is 5 crore, 50 crore and 250 crore rupees. Now, realizing the importance of this sector, the Government of India in Budget 2022, and which was later reinforced presently in 2023 as well, it has announced various schemes for MSMEs like extension of emergency credit line guarantee scheme, revamp of credit guarantee trust for micro and small enterprises scheme, and the rollout of raising and accelerating MSME performance, that is the RAMP program. So far as the rationale of the study is concerned, as we are focusing on MSME and IBC, looking at the unique attributes. MSMEs, if it gets insolvent, it may be treated at par with other organizations, but no, because of the unique challenges which are being faced, MSME insolvencies cannot be treated at par with other corporates, as MSME insolvency face unique challenges, like they can be over dependent on few customers which can lead to severe distress in unfavorable times. The MSME sector remains under stress from customers on one hand and suppliers on the other. Thirdly, they may face illiquidity, which can easily turn into insolvency. And as it involves so many people, the employment is to so many people, the liquidation can affect the livelihood of the employees of the enterprise. So maybe it becomes a vicious circle. It has been authenticated by this World Bank Group 2017. It notes that there are very few specialized legal regimes for MSME insolvency, as most jurisdictions treat MSME insolvency like other corporate entities despite of the unique attributes of MSME. But realizing all these things, to reduce the legal obstacles encountered by MSME for the liquidation or reorganization, UNCITRAL in 2021 adopted the legislative recommendations on insolvency of MSME, micro and small enterprises, which takes into account the unique characteristics of micro and small enterprises and the specific needs and circumstances of their financial distress. Objectives of the paper: there are fourfold objectives of the paper: to study the ecosystem and efficacy of IBC, to study the specific provisions of IBC applicable to MSMEs and relaxations available to them. Although the MSME could be operational debtor and operational creditor as well, but we have more focused on operational creditor. So to study the effect of IBC on MSME as an operational creditor. And fourthly, we have talked about the pre-packs to discuss the utility of pre-packed or pre-packaged insolvency resolution process for MSMEs. In order to achieve this, the research methodology which we have used, the literature was reviewed. Although there were not many things were available, we have based upon the primary data. Issues were identified based upon various annual reports, quarterly reports, or certain other publications. Various committees have been formed time to time, like by RBI or other committee, and IBBI has obviously been the major supplier, and MSME. So we sorted the data into framework. The SWOT analysis was carried out, and on that basis, we tried to give recommendations. Now my colleague Dr. Isha Goyal will take over.
So broadly, whatever are the objectives of IBC, they are also the objectives which are relevant for MSMEs. Like we want to maximize asset value, increase entrepreneurship, credit availability, equitable asset distribution to all stakeholders, timely resolution completion should be there. And evidence has shown that there has been increase in the financial flows. Time taken has reduced from 4.3 years in 2017 to 428 days in September 2021. India's improved ranking in World Bank's ease of doing business is there. Then operational creditors have gained a lot of bargaining power to reach out-of-court settlements. And IBC has also acted as a deterrent, which was being discussed in the morning session today, that many of the applications are not being filed, and even though if they are filed, they are withdrawn before admission. So all of those have also contributed to why IBC is relevant for MSMEs. Now, MSMEs can come under the ambit of IBC as a debtor or as a creditor. As a debtor, it could be a corporate incorporated MSME, or it could be a non-incorporated entity. But we find that in India, mostly MSMEs, they are non-unincorporated entities, and only a minority are corporate MSMEs. As a creditor, again, the MSME could be financial or operational, though mostly MSMEs are operational creditors and are usually financial creditors, only a smaller degree. For the corporate MSMEs, the pre-packed framework has been recently announced, and for the unincorporated, the CIRP standard MSME process will apply. Now, as a corporate debtor, what provisions are applicable under IBC? So, exemption has been provided under section 240, which has dispensed away the applicability of section 29A, clause C and H, which has enabled the promoters of MSME
to come out with resolution plans, because they are likely to be most interested in a resolution for MSME. And a pre-prac framework has also been proposed, but right now this is only limited to corporate MSMEs, though in the recent report even available on IBBI website, that they are considering a revision in this and expanding the scope of this to bring more units into the purview in a planned manner, so that our infrastructure is also not under a lot of stress. As a creditor, we said that mostly MSMEs are operational creditors and they face a lot of challenges because they can be left out of the entire CIRP process because they have not been given right to vote on the resolution plan, and even on the waterfall mechanism, they come after the priority has been given to the financial creditors. Even if they are financial creditors or as operational creditors, the longer the CIRP process will go on, the more costs it will have for the MSMEs. Now, pre-packs, they were introduced as the amendment ordinance, which was later converted into the IBC Amendment Act 2021. And under this, as of now, this is only available for corporate MSMEs. The control and possession of current promoters and management shall continue to vest with the corporate debtor. I just like to point out here that the pre-pack framework that we have in India that has been envisaged, it has taken learnings from various jurisdictions and the learnings from UK, USA, where it has been found to be very favorable, they have been incorporated. So on paper, it looks like a very attractive opportunity that is provided to MSMEs which want to go into for resolution. Like for example, in USA, debtor in possession model is there, and in UK, administrator takes custody, but in India, we have combined that with debtor in possession model combined with creditor in control to improve the system. So, but when we actually study that, we'll find that the response to the pre-pack framework has not been as per the expectation. Now, some of the features of pre-pack in India are that it is a consensual model. It's based on the mutual understanding between the corporate debtor and creditors. It provides for a reduced timeline in comparison to the standard CIRP. So 90 days to submit the resolution plan and 120 days to approve or reject the plan by AA. And it's a semi-formal mechanism. In the beginning, there is a consensus between the different stakeholders, and later on part, there's a formal process to give authenticity to the entire provision. Then we're saying that it's a less disruptive model, that we want it to be rehabilitated as a going concern basis because we want to maximize the asset value. And then in the morning session also today we were talking about the stigma associated with going in for that. So when we combine debtor in possession, the promoter retains the possession along with creditor in control, that no asset sale can be made without getting the creditors on board. So it provides a protection also, and it acts as a motivating factor also, so that the promoters, they can consider it as an option. But the data here is limited to what we've had available in December, but the latest statistics are that there have been 6 applications which have been filed for PPIRP, and out of this we also have one success story of SMS Paryavaran. But still the response is not up to the mark. The response has been lacking, and that is the major area for future work, to firstly find out what are the reasons why the response has not been as it would have been envisaged, and also to highlight the success story for what were the factors that led to a successful resolution plan. Now, if we combine all of this to say that where are we in terms of IBC and MSME, what does the IBC offer for MSME? So the strengths are that there have been exemption given under Section 29A and under Section 240A. Central government has been empowered to notify any non-application of any provision for MSME. Weaknesses are that CIRP process, it can be very draining for the MSME, and that is why we are saying that there should be that under pre-pack framework, more MSMEs should be brought under that purview. And MSMEs as general operational creditors, they can be left out of the entire process. Opportunity is the pre-pack which has been proposed, which is a timely, cost-effective, semi-formal mechanism. But the challenges are, the first challenge I would say is that the pre-pack framework to advocate, to work towards the advocacy of the pre-pack framework because of the low response that we see. MSME promoters may require assistance because we said that we want to simplify the procedures for them. So they may require some hand-holding. The insolvency professionals might need to be trained a particular way so that they can guide the promoters in a particular manner or even associate with them. Then at present, the pre-pack framework is only applicable to corporate MSMEs. And in the morning session also we were talking about the role of creditors, the financial institutions to also promote the pre-pack. So our recommendations would be, like, firstly, we need to conduct training programs, awareness programs to equip the MSMEs to basically highlight the advantages that the pre-pack framework has to offer. Then to expand the applicability of the pre-pack framework for other non-incorporated MSMEs in a structured manner, in a phased manner. Then setting up of NCLT special benches for MSMEs could be considered. We know that feasibility could be an issue, but that could be considered. And also out-of-court assistance for MSMEs. And here we can even learn from other jurisdictions to see, like in the morning we were talking about the Japanese model. So the experiences, the successful experiences, the best practices in other jurisdictions, how they can be modified and implemented in India, that we could look at. So to conclude, we would say that whatever are the objectives of IBC are also the objectives that MSME in insolvency would be looking at, and a developed IBC regime for MSME will also provide a further boost to this sector. And MSMEs as an operational creditor is one area where also we need to consider. One of the recommendations could also be that out of the entire CIRP proceedings, a certain percentage could be reserved for the MSMEs as operational creditors, or in some other way how we see that the concern of MSMEs as operational creditors should also be protected. And with the pre-pack frameworks, it is a globally recognized hybrid insolvency process. So we should now conduct more research to find out that how it can be gainfully employed, so that we can expand on the learnings from other jurisdictions and also the reasons for their non-acceptance till now, from whatever evidence is available as of now. Yes. Thank you.
Since introduction of this act, or this MSP Act, almost 2 years is going to go. Almost 2 years is over. Because you have presented in the first introduction also, you have told about 116 million people have been involved. I don't know whether it is both corporate and non-corporate people. That maybe that we must have studied that. Both non-corporate also, the most affected people are large numbers in this country. And their credit stake has not been protected. One thing that we have to admit that even after 2 years, the success rate has to go. It's a very, very big. Where is that? I mean, exact that point which is not taking up. Of course, Pune A, Pune C, Pune AC, and Hatch. Though there is a protection, why the promoters are not coming forward to take their own unit? That's a question. Maybe that in the yesterday seminar also that some of the respected speakers have admitted that unless lesser realization value as against that resolution plan. When there is an asset is available, yes, everybody will come. Promoter also will not lose. In this prepackage, even after 2 years, even the promoters, though that exemption has been given, and they are not coming forward, success rate is not that much. One more thing also in our observation we told about the protection for these creditors. The protection should be creditor for both non-corporate and corporate reserves. See, now that if there is a default in corporate, we can initiate ABC process. Similarly, if there is a default for this corporate, corporate has to receive the money from the non-corporate. MSME, non-corporate is an MSME, but there is no recourse under this. Of course, it is yet to be notified. It is there that it is yet to be notified. That's one thing. And one more observation is told about this. Some amount has to be reserved for this operation credit. You told, that. It is there. In the act itself, it is protected, fully protected. There should be no impairment in the resolution plan towards the creditors. So 100% whatever the dues is there, it is there in the act. It is there. It is there, 100% protected. Even not even 1 rupee you can reduce from the, unless in that corporate resolution plan where the asset is more, but in pre-package you cannot have anything. There is no impairment. That word has been used. So it is there. Still, why it is not being up in this? It is most wanted in this country, and why this MSME has not taken forward. Not necessarily this. This act has to be bring this resolution and liquidation. At least these unit to be protected. Resolution should be found out, and all this MSME should come up. And what is this? I think this study group and this conference should come out with some good solution. This is my submission.
Yes, sir. Thank you for your
I
question.
believe that IBC is responsible for sickness of MSMEs. Earlier, when she pointed out that they were out of court settlement, when the trigger point was 1 lakh, everybody feared. So you file an application and there is a settlement of an MSME. Now the trigger point is 1 crore. So large corporate is not really bothered. Though there is a reporting provision in the balance sheet and the interest provision, there is a mechanism where they can file the case if there is certificate and recover. But this trigger point of 1 crore has become a difficult situation. Their recoveries are being affected. For MSME, there should be a revision in trigger point for initiating an IBC against the defaulting customer. This has become a very big issue.
Perfect.
Yeah, sir, thank you for your question. Just to point out the part relating to the operational creditors and financial creditors. So what we noted was that the comparison of data of recoveries of operational creditors and financial creditors has shown that the recoveries of financial creditors was 42%, whereas the operational creditors recoveries have crashed from 49% to 14%. This was reported in the Parliamentary Standing Committee on Finance report. So the recovery for operational creditors, many times operational creditors have not realized value from the CIRP process. So that is why this suggestion for having a certain percentage of the entire CIRP value reserved for the operational creditors was there.
And because of the waterfall mechanism also, they fall in the last.
This is one of the reasons for their deterioration.
Yes, absolutely.
One of my clients had recovery of 1,000 crores from a company which has gone into bankruptcy. And they have been offered under the plan only 175 crores. So that particular client will go into bankruptcy if it is not a strong company. So it's a very strong company. We met Dr. Sahu. He said, what is the suggestion? He said, only one suggestion is you can come on the IBBI board, sit with us and try to work. Large suppliers for steel mills, SR, Bhushan and others, they have suffered tremendous amounts, and in fact the write-offs are more than 5,000 crore for steel mill suppliers, but they are strong companies.
Thank you, sir.
One more question, madam. Now the real estate companies, and infrastructure companies are doing the business more than 10 crores and 100 crores and all those things. Those are to be called as a SMSCs, or it is to be considered to separate law into the IBC. What is the kind of
Real estate.
real estate and MSME, real estate companies mainly, now they are doing the business more than 100 crores. Okay, those are considered under the MSME or any other sector.
Yeah, so I think, sir, your point relates to the misuse of provisions that was also being pointed out in the morning session today. That could be a challenge, like with the out of the 6 PIRB processes that were filed, 2 were trying to use it as a backdoor to be considered within this mechanism. So yes, that is a challenge that we would also need to take in the future. That
more clarification was fine. While financing lending, we differentiate what is the real estate finance and what is the MSME, manufacturing and service finance. We made a clear difference. But while coming to the IBC matter, as sir told that no, they wanted to take the protection of MSME because of the investment and turnover. And at this classification, they are very much command, they are eligible to, register under urban urban. And they wanted the protections. But real estate is, the home buyers has to be protected, the objective is most important, and that is to be protected.
Yes.
At the same time, these promoters should not take the umbrella of MSME to come out.
yes, that's also a challenge that we need to fight against. That misuse of provisions for MSME should not be there.
Sir, sometimes there is certain overlappings also. For the corporates, if you see, there is a provision of internal reconstruction, and for that the permission from the court is required. If we have a closer look at it, this internal reconstruction has been enforced for years altogether, since for many years. So if you, in internal reconstruction, somewhere when you take the permission of the court, from the debtors or from the creditor, you have to take permission. Like the equity shareholders, they have to forego a part of their capital, whether it is equity or it is preference. And you also see the from creditors, say if they agree to forego 10%, 20%, as per the settlement, whatever is the court, as per the agreement, right, the permission of the court is taken. So the asset value, the true value may be, brought to the true value. That those may be depreciated further. So the losses may be wiped off. So in a way, this provision is also there. So this in the Japanese model, when we talked about the voluntary or we talked about the guidelines, in India, certain other provisions are there like the arbitration and mediation. So the mediation is nothing but what when Japsa was discussing about this voluntary guidelines, or otherwise what he termed that as second company, that is mergers and acquisition in a way. So at certain places things are there when you are speaking about the real estate, the RERA which has come into force. Perhaps the need of the day is that all these things need to come together, but our focus is primarily on the fact that the PPACs, perhaps when it is available only for the corporates, and the corporates by normally speaking, the corporates are big ones, and if 1 crore, as sir has very rightly pointed out, if 1 crore default is there, of course for MSMEs it is lesser, but that way they are really not bothered. In case of corporates, there is a separation between ownership and management. When you talk about the sole proprietorship or partnership, when the managers and the owners are the same and their personal funds are at stake, so the difference may be there. This is what we are saying. What are your observations? I think your observations are in line with our paper only, to the best of my understanding, and very rightly pointed out by sir also.
Data 21-22, the recovery rate under IBC stood at 23.8%, while the rates under SARFASI Act and DRT stood at 25.7% and 22.5% respectively. Now, the motivation for this study is this. The IBC has faced a lot of challenges with the classification of willful defaulters and fraudsters. In some cases, what happened, corporate fraudsters were declared fraudsters or willful defaulters after the resolution process or liquidation process. And in some cases, stakeholders found the companies as fraudsters after the resolution process. The creditors found during and after, whereas stakeholders, the shareholders found after the CRP. So the lack of a proper whistleblowing mechanism in the IBC is noted as a relevant issue to consider, and this whistleblowing mechanism can help identify many corporate fraudsters before and during the resolution process. So the research questions we had in our mind was, when to classify a corporate fraudster under IBC? Does IBVA need more cooperation with RBI? And who will classify the corporate defaulter as a fraudster? And where is the proper whistleblowing mechanism in IBC? So with these research questions, the main objective of this research was to check the efficacy of section 29A in terms of timely classification and authority who is responsible for it. And second objective, to suggest suitable measure to overcome the practical limitations faced in CIRP. And now secondary objectives we included to advocate the timely classification of the corporate fraudster as the fraudster, and to identify the authority to classify the corporate fraudster, defaulter as the fraudster, and to suggest a proper whistleblowing mechanism in IBC. So the research methodology, we were actually having lot of limitation in accessing the data. Very little data were available to us, and few case studies were available, but with these things we were trying to bring out some important insight for the benefit of IBBA. That is, I think we are very happy that our piece of research has been selected. We are very interested to work further as well. So this is a case study method. We have collected 3 case studies to bring out this insight. Secondary data, more than these case studies, we also read reports, media news, all those stuff, and content analysis of the case studies were done, and we have brought this insight. Now over to my scholar, Bhima Mol, for the findings and discussion.
So here I will explain about the key cases which are around here. And actually, as ma'am mentioned, it was very difficult to get the complete data of even the cases. So here we have chosen only 3 cases for explaining, like for going through all these research questions as already mentioned. So the first case is Amtech Auto Limited. So here we all know that we all read the news that actually I give a brief introduction about Amtech. It was established in 1985, and in 2015, SEBI declared Amtech account as an NPA, and in 2017, it's a white order has, based on the white order, that CIRP process has started, and in 2020, NCLT has approved a resolution plan for the Amtech. But after that, that allegation is coming. In 2022, there was one whistleblower came up with an allegation that there is a fraudulent activities happened in Amtech. So after that, in September, IDBI has declared Amtech promoters as a fraud. They have done fraudulent activities. So all those, like all resolution process has completed, and after that it is coming up as there is a fraudulent activities committed by the promoters, and also that was dilution of fund was there. So here I'll explain with the next case.
In fact, IDBI was in consortium finance with SBI.
Here, during the resolution process, even forensic accountant couldn't find out that there is a fraudulent activities happen. And after completing the resolution process, if any allegation coming up with that, and then after one of the consortium bank is declaring as the promoters were the fraudsters. So here that benefit of the 29 is not really, like 29A is mentioning that ineligibility to apply for the CRP process. So here that all the company has gone through all the resolution process, and after at the end it is coming up as there was a fraudulent activities already happened.
Next case.
Next case is on ABG shipyard. Like it was established in 1985, and the account has declared as an NPA in 2013, and CRP started by 2017, and since the resolution process has failed and there was no buyers, it was went for the liquidation process in 2019. But after that, in 2019 April, 29 April to 29 March, the account has declared as a fraudulent account. There was an SBA has came up with that there is a fraudulent activity already happened with the ABG shipyard, and after that there was a forensic audit done, and based on the result it was came up that from 2012 to 2015 there was fraudulent activities happened. So here that the process of whole CRP completed and liquidation has also done, then it is coming up as there was a fraudulent activities. So likewise the other case of Bhushan Steel, established in 1983 and then defaulted by 2014, and the resolution process accepted in 2017 and completed by 2019. And 2019, Punjab National Bank has detected their company as a fraudulent company, and they have done the diversion of fund and other financial statement frauds. So here comes how can you ensure that the relevance of 29A here, because 29 is mentioning that ineligibility to go through the CRP process, but these companies have gone through the CRP process, but after that it is detecting as the fraudulent company.
So what we are trying to suggest here is to close this loophole. Actually, it is a regulatory dialectic mechanism which takes into account any kind of loophole when it is incited or found by any of the practitioners or academicians. So we try to close the loophole. So here, after the application is submitted to CIRP process, and we have the process of appointment of IRP, and then the appointment of forensic auditor is now mandatory, and in between that time we should have a time period, maybe say 30 days we are suggesting, maybe IBI can look into that time, and whistleblowing mechanism information should be considered by IBBI giving 30 days, maybe a public notice. This is what we are trying to go for CIRP process for this company. Any whistleblowing blower would like to anonymously give such information. So those protection to those whistleblowers can be ensured. Maybe we can give a short window. During that time we can get information so that we can identify those fraudulent companies. And again, in the appointment of forensic auditor, now the forensic audit report is now mandatory. They are considering only 2 years data, by which again we are not able to predict really are they a fraudulent company. So we should consider at least 5 years. And the rest of the resolution process we are finding it very okay. So here what as academicians we could contribute is, we can, if you are giving the data of 5 years, we can bring out a model like how RBI is having credit scoring model. We can bring out how to predict it is a fraudulent company or not. So that empirical model we can work out, one thing. Second thing, in the whistleblowing mechanism, IBBA has to throw some light what is the time period, what kind of mechanism they can have that they can bring out. That will definitely help to increase the efficiency of 29A, we hope. So all secrecy and protection of the whistleblower based on public interest disclosure and protection of informers resolution, and the rewards can be given to whistleblowers who voluntarily provide original information, and it should be anonymity should be maintained for the safety of the. So now another important question, who will classify the corporate defaulter as corporate fraudster? Because IBBA follows just the definition given by RBI. And do we willful defaulter? Who is a willful defaulter? The same definition we are following. And here also, and when to classify. These two questions, if we answer, then the efficacy of 29A, section 29A can be increased. So now it was evident that in Amtech case, there was no proper whistleblowing mechanism. In ABG Shipyard and Bhushan Steel late fraud detection due to the absence of mandated forensic audit, and the IBBA must allow time for whistleblowers before proceeding with the RP process, that is RP, and must assume their confidentiality and protection as stated in FIT B. And in addition, subsequently under section 22A, before beginning the resolution procedure, IBBA must make sure that the corporate defaulter is not fraudster through a mandatory forensic auditing process, and improve the scope of forensic auditing, number of years of transactions, because forensic auditors are also, we were also discussing with this IRP professionals, they want to safeguard themselves. Later, the company was found fraudulent. No, I have gone through the data what was given to me. That they are getting away with the safety mechanism. So we should go in letter and spirit that importance of forensic audit report. So these are our suggestions. With the very limited available data, we were able to bring this insight. If IBBA gives more data, we are ready to work with the organization. Thank you for this wonderful opportunity. Questions, please.
Can we start?
Yeah, sure.
Yes, sir.
So you have linked your study to section 29A.
Yes.
So section 29A is with a disqualification for an applicant to submit a resolution plan. So how that a corporate debtor or maybe the company who has done default, how that can be linked to 29A?
Actually 29A deals with the CIRP, that is corporate insolvency resolution process. But before they are eligible for that process, some mechanisms are there, some processes are to be checked, or information is to be checked that they are not fraudulent defaulters.
There is mention like willful defaulters are not eligible for the CRP.
Yes.
Right? So that is based on the what RBI is classifying as a willful defaulter. Right? But there are some cases which we have seen that later, if it is like the company has gone through or entered into a CRP process, after that RBI is declaring or any bank is declaring those companies as a fraudulent company, then how? Then what the relevant of 29A?
Again, one more thing, the original promoter who was really a fraudster, and they are getting away without any punishment or anything. Because now in case of the second company or the other investor taking over the company, and they say that we are not responsible for this. But what about those? Again, that is another point of research we could think of. Based on the whistleblowing information, those cases can also be taken up through PLI cases or whatever it is. Maybe the legal expert can also throw light on that. How we can deal with those real promoters.
When the forensic auditing is happening, like doing, that time they are going through only for the limited data. They're like, based on that, they are concluding that this company is not having any fraudulent past or something. So like that, if they conclude and then they are going for the CRP process, later some of the financial creditor is coming up with the allegation that this company has done some diversion of fund, then how IBC will take care of that, and how even if after completing CRP process also?
No, this is only one of the conditions. Full defaulter is one of the conditions. The other condition is that if it is NPA, if the account is NPA for more than a year, so normally whoever is a willful defaulter, because there is a process for identifying and saying that he is a willful defaulter, and banks take time to undergo that process. But in none of the cases, as far as I remember, none of the cases they were eligible applicants, resolution applicants, because they were not satisfying other conditions of section 29. That is, their NPA was for more than a year. So It is not that because of that they were benefited in any manner. This is the point I am trying to make.
But in case of Amtech,
You have mixed 2 points. First of all, section 29 is applicable for the resolution applicant, not for the corporate debtor. Section 29A is applicable for the resolution applicant. So resolution applicant should not be the willful defaulter. So you have mixed.
no, but how CIRP allows after checking this?
No, you are mixing 2 things. Your concept is not very linked with the section 29A. Section 29A only deals with the resolution applicant qualification. Your thing is these companies are the willful defaulter and after CIRP banks initiate the willful defaulter. That is not linked with the 29A.
That's for my question.
Yes.
Please don't repeat everything you will do.
No, from our limited data, we thought this is one insight. Maybe we have to.
One question I have, very basic question. I don't know this field very well. It looks like your proposal has to do with salience, in the sense that you're saying that the whistleblowing option should be made more salient. That seems to suggest that there are no options for whistleblowers to act currently, or there are some costs which prevent them from doing so. So do you have a sense for what these costs are? And have you looked at, for example, the SEBI would have many regulations related to corporate fraud where a whistleblower option is provided?
Sir, LODR has this policy as mandated one, but LODR, listing obligations and disclosure requirements, they give more importance for this whistleblower policy. And recently that NGRBC, National Guidelines on Responsible Business Conduct, the first principle talks about these policy mechanisms. So
the idea is when you make something can be done freely, even without a law, it will happen naturally. So what is the benefit of salience in the act?
Our research question emerged because after reading the Amtech Auto case, so why it was declared later fraudulent? So why not before? Why they were allowed?
All I'm saying is there could be other reasons. So if you're taking the point of view of the whistleblower, let's look at their incentives. There are some benefits and there are some costs.
Yes.
For the whistleblower. How does your proposal address those? You're not explaining why the costs have become lower for the whistleblower and the benefits become higher. I'm not able to follow.
Yeah, we have just started that part and we are yet to move forward towards that. So we are just giving a suggestion so that whether if IBBI takes this into account, then we can do further research and we can give a framework.
First, if you have to articulate the benefits and costs.
Okay.
And both the whistleblower and to the affected party.
Okay. We take that suggestions.
Thank you for the presentation. Now I would like to invite our second presenter, who is partner at Samvad Partners, and she co-heads the firm's insolvency and restructuring practice. Her paper is titled Avoidance Applications and Their Potential for Unlocking Value.
Great, thanks everyone. Good afternoon, and I'd like to thank IDBI and IIM Bangalore for this opportunity. I also want to introduce my co-presenter, Akash Sherwal, who's also who's a senior associate at Samvad. So our topic of this paper is avoidance applications and their potential for unlocking value. And as everyone knows, I won't go into too much detail on what avoidance provisions are, but basically under the CIRP process, for the first time in the IBC, they actually place a positive obligation on the resolution professional to go through the books and records of the corporate debtor and unearth these sorts of transactions that were either gave a preference to a specific creditor, were undervalued, or were fraudulent in some manner, such that they can then apply to the adjudicating authority for a relief, such as basically returning that value back to the corporate debtor for the benefit of creditors. So this is broadly, and there are many kinds of avoidance provisions under the IBC, which I won't go into the details here because I'm sure you all know them. There are preferential transactions which deal with giving a preference to a specific creditor over others. And then there are, of course, undervalued transactions as well as fraudulent transactions where, either with the intent of defrauding creditors or, siphoning assets, etc. So broadly speaking, what we've looked, and right now it's fairly become very common to file these avoidance applications in the CIRP process. We actually found, based on data, that there have been about 809 avoidance applications as of September of last year that have been filed. And the recovery amounts in these avoidance applications are really enormous. They go up to 2.2 trillion INR. But actually, and there were some cases which really set the stage for this, but which suggested that there is a lot of potential. There were some favorable orders from the NCLT, even right up to the Supreme Court, recovering this value. But at the same time, most of these applications don't get heard in time. Most of the time, their value is not actually recovered, and we know that despite 809 applications, fewer than 100 applications have actually been disposed of for various reasons. And so then the recovery here is extremely low. So what we were trying to do is look into what is the context. We're trying to contextualize these avoidance provisions in the larger context of the CIRP process, what they are trying to achieve. And through looking at various important cases on avoidance applications to date, we were trying to see what are the learnings from this, what are the difficulties faced by the adjudicating authorities in disposing of these cases or coming to a conclusion in these cases, and various other practical difficulties that we came across through the case law and our own experience. We're both practitioners in this area in terms of dealing with this to suggest certain ways forward. A caveat we have here is that, of course, these are all very specific and unique situations. So I think it's going to be very difficult to have a one-size-fits-all approach for all avoidance applications because they are very fact-specific ultimately. So our aim is more as a starting point to identify certain patterns, identify certain issues that are commonly faced in these cases and look into how these can be improved going forward. So first of all, to contextualize the reason we need avoidance provisions under the IBC. The first reason, it really goes into the nature of the insolvency resolution process, which is supposed to be a collective process, where there are specific kinds of treatment for different classes of creditors. So if a particular creditor has been given a preference in the lead up to insolvency, that compromises on that collective process and being able to for equality of treatment. And it also deals with, while the IBC is not intended to be a punitive legislation, there is a tendency in a lot of cases for promoters, companies in the zone of insolvency to enter into side deals with creditors during that time to try to, give certain creditors, take certain kinds of transactions at that time, including perhaps moving their assets, etc. Is that better? Sorry. Yeah. And so that is another reason to prevent this kind of any sort of, as a sort of incentive to prevent fraudulent activities, particularly in the zone of insolvency. They also, of course, go along with the IBC's goal of maximizing value for all stakeholders, because if there are favorable orders passed in these kinds of cases, then the recovery potential is very, very high. Lastly, it also brings a more of a discipline and transparency into the whole insolvency resolution process, because for the first time there is an obligation on the resolution professional to go into really do a deep dive into the books and records of the corporate debtor. There's also a positive obligation to, if there are such transactions identified, in that case the resolution professional does have to make an application to the adjudicating authority. And related to this, because of this, there's also the practice of resolution professionals making sure there are transaction audits being carried out during the CIRP. At the same time, we should understand that there are certain costs and disadvantages of avoidance provisions, which we need to sort of keep in mind when we think about the broader policy perspective. One of them is that they do bring uncertainty in terms of contract, right? In terms of the sanctity of contracts. Because some of these transactions, particularly preferential transactions where there is a deeming provision, would have been perfectly legal if not for the zone of insolvency. They might have been. So it does lead to some amount of uncertainty for contracting parties, and this is something that has been widely discussed in the literature as well around avoidance provisions in a number of jurisdictions. The other practical difficulty is that the IBC, the CIRP, is supposed to be a very time-bound process. But these transaction audits, gathering evidence, all of those things take a long time. And unlike other kinds of orders or applications made to the NCLT, they also require a lot of detailed review by the NCLT of the evidence, and generally very often don't fit into the shorter time period that's provided in the CIRP. And they also, and as a result of this, they also bring in various third parties that may not be directly involved in the insolvency proceedings itself. And all of this does lead to greater litigation, greater costs, and ultimately it is something that the Committee of Creditors has to decide how much do they actually want to progress with these applications. So there is a balancing act, and I think it's important to keep in mind that there are two sides to this coin while we go into the case law. So my colleague Akash is going to go into some of the findings from the case law, but I just want to talk about the first case, which is a landmark judgment of Anuj Jain versus Axis Bank Limited. And in this case, this was one case that really provided a lot of hope that there could be a huge amount of value recovered from these transactions, because in this case the Supreme Court, this case went right up to the Supreme Court, and the Supreme Court set aside mortgages over land that was actually valued at over 4,000 crores. So this was a huge recovery to the corporate debtor. And it also clarified a number of points around avoidance applications. The Supreme Court actually gave a very detailed checklist of the procedure in which and how an RP or a liquidator should actually go about figuring out whether there are avoidance applications, a particular transaction should be avoided. And in this case, they also pointed out that there doesn't necessarily have to be a debtor-creditor relationship. In this situation, the corporate debtor was JP Infratech, which had given a mortgage to the lenders of its parent company, Jayaprakash Associates Limited. And in this case, they were not, of course, there was no debtor-creditor relationship between those lenders and the corporate debtor. But of course, JAL, the parent company, was a creditor of the corporate debtor. So they said, as long as you were giving a benefit to another party, the beneficiaries of the mortgage were very clear. In that case, that was sufficient to claim that a particular transaction was a preference. The Supreme Court here also placed a positive obligation on lenders, saying that it's up to the lenders in any transaction to know that, the parties are in financial difficulties. There could be a possibility of a preference, and therefore we shouldn't really assume that, the lenders tried to say this is a very common kind of transaction. But the Supreme Court was clear that it was up to the lenders to investigate into the parties, including the parties from whom they were taking third-party security in the lead up to insolvency. So this was, of course, a very useful case, and it provided a very good framework for looking into avoidance applications. But I think after that, there haven't been too many such cases, and recoveries have generally been low. I'll now turn it over to my colleague Akash, who will go into some of the additional cases and our learning from there.
Thank you, Abhay. Hi, good afternoon, everyone. So, as a part of our case analysis, when we were looking at judgments surrounding the avoidance transactions, one of the most common aspects that we found that the courts frequently dealt with was to what extent the transaction audit report, or the forensic report as it is commonly known, can be relied upon by NCLT while holding a transaction as preferential, undervalued, or fraudulent. Now, we saw cases on both sides of the spectrum. There were certain judgments, as the one you see on your screen right now in Vijay Lula versus Technova Plastic Industries, where the NCLT held that there has been an undue high reliance upon the forensic report, and hence the application to set aside the avoidance transaction was dismissed. A similar view was also given by NCLT in Bank of Maharashtra versus Visa Power Limited, where the AA observed that transaction audit report relied upon the liquidator did not present sufficient material to prove that transactions were preferential. Now, this is a frequent problem, I believe, as practitioners of law, we can relate to, that NCLT might face. That when you're looking at these transactions, in essence, you are required to review evidence in order to give a finding. Now, NCLT, due to its summary process, usually relies upon a broader framework of information utilities as well as other sources to give any findings regarding admission. However, in certain contexts, the NCLT, I would say, did not object to the reliance on the transaction audit report, whereas to say that the NCLT relied upon it. In Suresh Kumar Jain versus Adriatic Seafoods, the adjudicating authority relied on the transaction audit report to set aside the avoidance transaction. This case involved the sale of a plant by a corporate debtor at a significantly lower price in relation to the NOC value which was recorded by the bank, by the mortgagee bank. Similarly, in Radico Trading Limited versus Tarun Batra, NCLAT again did not object to the reliance on the transaction audit report or the forensic report for setting aside the avoidance transaction. In these two cases, while I may just point out here, while the reliance on the transaction audit report was not questioned, the amounts involved were so far apart. For instance, in Radico Trading, the book value of the plant and equipment of the corporate debtor was 1.5 crores, which was sold at 21 lakhs. So the value was so apart that the transaction audit report, I believe, was just one of the factors that was considered by the A. And now this brings us to the ultimate question as to what is a way to better, and I believe the reliance on the transaction audit report by the IPs presents many challenges in terms of NCLT members or even NCLAT placing reliance upon it to give a finding in avoiding the transactions. I believe a suggestion here which we can give here is that prescription, guidelines, regulations, or a format, if you can call it, may be given for the transaction audit report so that it is easy, of course, based on principles of evidence which can be upheld before NCLT or any other court of law, which can make it easier for the resolution professionals to kind of deal with forensic auditors and also allow a semblance of underpinnings of any transaction audit report. Because in our practice, we have seen transaction audit reports which are frequently unaccompanied by the materials on which the audit report has been prepared on. So even if it is, say, tally data or vouchers, this is something that many transaction audit reports do not clearly disclose as to what is the underlying material they have relied upon to prepare the report. In certain cases where survey of lands are involved, we have heard from forensic auditors that they surveyed the land through a video call which was conducted by someone from IP's office. So, a common underpinning of guidelines and regulations as to in what manner and what level of detail a transaction audit report covers will help both the IPs in kind of relying upon them, and will also help the adjudicating authority in passing decisions to avoid transactions based on them. So that was the first issue that we identified through our case law analysis. The second is that there is an ordinary course exception provided within these avoidance provisions, which is when is a transaction not hit by these avoidance provisions. Again, there is a general lack of case law about what can be covered as a part of these ordinary course exception. The two significant jurisprudential aspects that we could identify was one, that NCLT or the AA looks into the industry practices while determining the ordinary course exception. In DP Mehta Parag Distillery Private Limited versus Shivani Amit, the AA held that the change in the nature of business from sale of liquor to going into bottling was an accepted industry practice, and hence this transaction is not an avoidance transaction. There was a allegation that 43.85 crores was lost by the CD. Similarly, in the other case, which is Venkatashan Shankar Narayanan versus R&T distributor, the A made a distinction between priority payments, which are payments which may be required to be made in the zone of insolvency to keep the business as a going concern, from preference transactions. So these were, I think, the ordinary course exception is something we also feel that it will evolve on case-to-case basis as we move forward. But there is a need to kind of be aware of the industry practices when you're dealing with the avoidance applications. Other than this, the next part of the presentation on the paper as well deals with the survival or the continuance of the avoidance transactions. Now, this is an issue which has already been litigated sufficiently in terms of the first judgment that a lot of IPs rely upon, which is Venus Recruiters versus Union of India, where the Delhi High Court held that avoidance application cannot continue once a resolution plan has been approved. The judgment did leave the window open that in case the resolution plan provides for it, the avoidance applications can be continued. Of course, now that has been statutorily introduced through an amendment. There's subsequently the NCLAT judgment of 63 Moons Technologies gave a finding where the potential recoveries from the avoidance applications could not be applied for the benefit of the resolution applicant, but only not for the resolution applicant, but only for the creditors. And the last judgment, which I'll just spend a minute before handing it over to Aparna for the conclusions of the paper, is the recent judgment of Division Bench of the Delhi High Court, where they set aside the previous judgment by the Delhi High Court and held that the adjudication of avoidance applications is independent of the insolvency resolution of the corporate debtor. So if you look at the entire scheme of the code, the avoidance applications stand on a different footing, which will survive the approval of the resolution plan or continue during the liquidation period. It was also, and I think this observation may have implications outside the area of avoidance applications, is that RP shall not be functans officio even after the approval of resolution plan as far as the adjudication of avoidance application is concerned. And lastly, the Division Bench of the Delhi High Court also held that the amount made available after the avoidance of the transaction cannot go to the resolution applicant and is for the benefit of the creditors of the corporate debtor. So in this sense, it echoed the findings of NCLAT in 63 Moons Technologies. And the 63 Moons Technologies NCLAT judgment is right now sub judice before the Supreme Court. So we'll see if this aspect is upheld as far as the fate of avoidance application is concerned. Lastly, I'll hand it over back to Aparna for the conclusions of the paper.
Thanks, Akash. So just very quickly to summarize some of the key takeaways from this. One is, as Akash already pointed out, that in terms of the evidence and the ability to rely on transaction audit reports, the kinds of reports that are produced, I think there needs to be a lot more standardization. This is something that a lot of tribunals are struggling with, and there are very varied policies around this. Apart from that, the biggest issue found is that there's a lot of delays in actually adjudicating these applications for a couple of reasons. One is, of course, that the rest of the CIRP process can continue regardless of this. So in some sense, a lot of times these are not agitated to the same extent as various other applications. And it's helpful now, this latest case, which actually came after we had written this paper around the most recent Delhi High Court judgment, which makes very clear that avoidance applications can proceed post approval of a resolution plan. That is very helpful, but at the same time, there needs to be more than that to figure out who will actually be able to, how will these be continued after the resolution plan approval, because most of the parties may not be interested in carrying it out. How will this be funded? I think it's both a cost issue and also ultimately, if they can continue, for how long can they continue? Because we also do need closure for the different parties. So those are the different main issues that we can think of in terms of time and cost, and also the value of evidence. So, thank you. Questions.
Thanks for the wonderful presentation. Now I can open the floor for question answers if anyone
I would
has.
like to make two points.
Maybe I can just start.
Number one, Venus judgment.
Excuse me, I have a right first to ask.
Yeah, sir, you can please start. Shri Amit Pradhanji, can you please start?
That we have first like.
Yeah. You are secure creator here.
I am exercising.
Yeah.
So, what I have understood with your study, like detection of this avoidance is a problem. Maybe I just go back to the previous paper where this whistleblower mechanism was suggested. Will it be a good idea here? That's my first question. And second, how can avoidance matter be expedited? Do you have any suggestion? Maybe when IP takes over it, it's too late. Maybe it can start at the creditor stage only. Means they should start finding out this default or maybe these frauds or maybe this buffet kind of things. Maybe start very late or in detection of this, diagnosis of this.
Yeah, so I can maybe take the second question first, because of course I think the time period for detecting this is very short, because after it. But the issue with probably trying to detect it earlier is that the RP has control only as of admission or when the moratorium comes into effect. And even at that point, very often the promoters don't necessarily cooperate immediately. So that whole process of getting information is a major problem. So so I'm not sure on what grounds prior to admission the COC or anyone would actually be able to go and find this information. So it would be very helpful if they can, or if you can have something to say that on admission, without the RP actually requesting for it, the corporate debtor has to provide this sort of information to the RP. I'm just thinking out loud here, but you're right, because I think by the time we come into the CIRP process, it is a little late to start that, but I'm not sure how it can actually happen before that. I'm happy to hear thoughts on that. Sorry.
Can help.
Yes.
As an RP, my first step with my COC is, please give me your forensic audit reports if you have carried out. Please, if there are any inspection observations by your inspectors, and I am entitled for that information, and I share it, because the code provides that I have to form an opinion. I should not just blindly say that I would go ahead, this has promoted thing like that, because if there is no conclusive evidence out of the transaction and forensic audit, that means I made a wrong and futile decision. The second thing is, I am handling a CIRP where 19 things happening, promoters are in jail, no records are available. So when I give an assignment, I tell the person there that we will be going through the banking reports, MCA reports, and we have 250 crores UFA applications without a single voucher with us. So the auditor should have tools, modern tools to extract this because there are tools available. Though without report it is very difficult, but MCA data is this. And the third very important factor which your colleague had said, I tell my forensic auditor I need a conclusive and a report with evidences. Otherwise, I will not pay your fees. Because a lot of large firms are giving me reports which are inconclusive.
That is
And they
something
are
we
just
observed.
confusing, go round. There is no determination. You are just giving me that feedback. I need a conclusive report. With regard to Venus, you see, the resolution plan must provide how are you going to deal with this. In Venus, that gap was left.
Yes.
That is why the Delhi Chief Justice, I have had discussion with him, the order needs to be really reviewed. That is why in Venus he has clarified that the RP will be continuing and his fees will be settled by doubling. So the resolution plan, whichever are approved, we must provide how will it be handled. Who will deal with it?
Yeah, absolutely.
Where will the funds go?
And I think now
And who
that
will
is
bear
very
the cost?
clear. That is also very clear now that the resolution
Yes.
plan is supposed to be. Thank you.
Yeah, one quick question if you have. Yeah.
That was something that the NCLT actually said. No, it's not defined. I think what they were trying to say in that particular case is that not every, that any time that there may be a business reason to sort of prefer somebody over another. It's a very gray area, and I don't know if we can, follow that as judgment, but that was something that came across there, that what they were trying to say is that there's a bona fide business reason for doing this. Not every time you give a preference is a priority, a priority is a preference, is what that judgment said. But yeah, that's right. Yeah.
So we have a.
There's a question from online. Yeah, can I? Yeah. Yeah.
Sorry, I was looking at it.
Am I?
Yes, please go ahead.
Yeah. So my name is Anil Katia. I am also an insolvency resolution professional. I hope you can hear me out.
Yes, we
So
can.
let me put this in context. Yeah. First of all, in your first slide, you said that RPs can investigate. There is no provision whatsoever which allows RPs to investigate. It's the liquidators who are allowed to investigate. So your presentation, first slide line, I don't know from where you have got that. That's one. Second, in order to really make this work, what we need to do is, we need to have the look back period start from the date of filing of the application. That is how this gap will be plugged. The creditors will never pursue avoidance applications or avoidance transactions at their own end. It doesn't work like that. We have to see if that be the case, even before IBC was enacted and put into place, this would have happened. The creditors actually don't like to pursue that. So the RPs actually have a fiduciary duty and very well articulated in the law. So it has to be done by the resolution professionals. Then you have to allow resolution professionals to have summoning power for any investigation to happen. You have to allow him to summon the parties involved in the transaction. That is missing in the law. Then you also have to allow the summary proceeding court to appreciate evidence. Today, the way NCLT works is largely in the format of summary proceedings. So we have to move from summary to really a trial court kind of a proceeding. So these are some of the gaps which I have noticed. I have been making these points before the regulator. I think it's high time. We have so much recovery to be done under avoidance applications, but nothing is really moving. So that's my take. Thank you.
Thank you, that's very useful. I think especially this look back period, that is something, I think there have been suggestions on that before as well. I think that is important because sometimes these applications are filed and then they are actually admitted much later. So, the look back period should go from the time of filing. So I agree with that, and I also take your other points. Thank you.
Thanks for the presentation. Now we'll move on to our next presentation. So our next presentation is by Mr. Vishnu K. Ramesh, who is an assistant professor in the area of finance and accounting at IIM Rohtak. And his paper is titled, Do Creditor Rights Really Impact Borrowing? Firm Level Evidence from India. He'll be presenting online. So may I now request Zoom details to be used.
Yeah, am I audible now?
Yes, you are audible.
And is my screen visible?
Yes, not yet.
Okay. I think, yeah, I have shared from my end. Yeah, it's.
Yeah, you are allowed to share the screen.
Yeah, I have done that. Are you able to see my slides? Okay, what about now? Yeah, what about now? Okay. Yeah, okay, so yeah, the navigation is also clear, right?
Yes, the audio is clear and your screen is also visible.
Okay, so fine. So let me start. Yeah. Thanks for this. Yeah.
Can you move on to slideshow?
Can I? Okay, yeah, sure. Is this clear now?
Yeah.
Okay, so thanks for this wonderful opportunity. I thank both IPPI and Indian Institute of Management Bangalore for this excellent opportunity. So without any, time, let me start this. So my our work is titled as Do Creditor Rights Really Impact Borrowing? So we all exploited the insolvency bankruptcy regime and what was the impact of that particular regime on the borrowings made by listed firms in India. So unlike some of these works which has been already presented in this conference, which are mainly case-based things, we are providing an average view. So we took some sample firms and looked at how the insolvency and bankruptcy code impacted the borrowing decisions of Indian firms. So if you look at the preamble, the research question is that, did insolvency bankruptcy code really work in corporate debt market in India? So our finding is that it's mixed. So the context is that India introduced IBC in 2016, and it's a radical measure because we already had previous acts like Sikh Industrial Companies Act, RADBFI, SAFESI Act. But on top of that, we had a comprehensive code which is titled as IPC and how it really impacted the borrowings. Now, we did two popular methods. One is pan regression, and to identify the impact, we also looked at the difference and difference models. And the findings indicate that it seems IPP did not work as intended. Despite earlier evidences, some of these anecdotes do show that India scored better in bankruptcy regimes. Now, question about creditor rights. So IBC empowers the creditor. So are creditor rights and corporate financial policies related? That is the first thing. So of course they are related, and there are two major arguments. One is from the supply side, that is from creditor side, and one is from the demand side. So from supply side, that is from creditor side, they say that if you strengthen the power of creditors, if you give more power to creditors, they will be happy to provide more and more loan. So they say that the creditors or the proponents of creditor rights say that you increase the creditor rights. That will help the creditors to provide more loans, which means there exists a positive association between supply of credit and creditor rights. So higher the creditor rights, higher would be the supply of credit. So this started with the LLC literature by Laporta and Schleifer, who said that higher the creditor rights, better will be the supply of loans. But there is a demand side of that. So demand side says that, no, if you increase the creditor rights, the borrowers will be fearful of borrowing because they know that they will be having less bargaining power. So demand side says that higher the creditor rights, there will be a downside impact on borrowers. In fact, in the context of India, Vikrant Vick's 2013 paper, which explored Suffici Act, found that increase the creditor rights, people will reduce the borrowings. People means the Indian corporates will reduce the borrowing. So empirical evidence is mixed. So what was the pre-IBC condition? It took almost 6 years to resolve most of these bankruptcy cases, more than 6 years, so it's an average. And because of the weak creditor rights, India also had historically led to low recovery rates. By the end of the time the banks could recover, they could barely recover 20% of the value which they gave. So these were the conditions. So the highlights were, I don't want to go through it because it was already mentioned. So IBC got entered in 2016 and insolvency of bankruptcy procedure moved from a debtor-in possession. That means nowadays we will be having a control which is in the hands of creditors. So we moved from a debtor-in possession to creditor-in control regime. And there is a strict enforcement of timeline of 180 days to maximum 330 days. Some of these anecdotes in newspapers all say that this is not being met. But yeah, at least we can say it in writing, it's 180 to maximum 330 days, unlike the case of 6 or to 7 years. So motivated by this shift from a debtor-in possession to creditor-in control regime, we look at how actually IPC affects Indian corporate market. And now Indian corporate market is different because we have firms which are predominantly owned by promoters. So unlike the case where, say, US, where you can strengthen the creditor rights and where you have widely held companies, India we have closely held companies. So if you are having closely held companies, then what will happen to the borrowings of such companies in a regime where creditor rights gets increased? So that is what we look at. So Indian institutional environment, as most of us know, firms in unlike firms in developed countries, we don't have much institutional investors. Institutional investors percentage is around 5 to 6%. Indian firms are heavily characterized by concentrated ownership. And of course, there are also dubious role of promoters who use delay tactics to prolong the bankruptcy process. So India is also known for all those dubious tactics played by the promoters to make sure that the bankruptcy things are being prolonged. And of course, Indian firms also depend heavily on banks for external finance. So out of 100 rupee borrowings, about 60% comes from banks borrowings. Now, given this context, so this makes Indian context interesting. So you are having a heavy dependence on banks. At the same time, the promoters who use these funds will do a lot of tactics to raise these resources, and at the end they will say, see, we don't have any thing to pay back the money. So that was how it happens, and at the end, bad debts in the books piled up. So even in the context we investigate the ex post impact of, that is what we call as an economics impact evaluation of the strengthening creditor rights using the data from India. Now the question is that, do firms increase their borrowing after the passage of IBC? That is because if creditor rights are good, then firms will be happy to borrow more, which means after the enactment of IBC, you will see Indian firms increasing the borrowings. That is in line with the supply side argument. On the flip side, if firms are fearful of the IBC, then they will borrow less, which says that firms will decrease their borrowings on the passage of IBC. So this is what we are investigating. We also look at how there is a change in borrowing mix, like is there a change in secured borrowings, is there a change in unsecured borrowings, short-term borrowings, long-term borrowings, like this. So, I mean, I don't want to, so this is the gist of this, the supply side will say that, okay, higher the creditor rights, higher will be the borrowings. Why? Because creditors will be happy to lend more. On the other side, if the demand side works, that borrowers will be reluctant to borrow because they fear that a stronger creditor rights will reduce their bargaining power. So, now we have already a lot of multi-country studies. So the problem with multi-country studies is that you say that, okay, in common law countries, this is how it works. So it's like averaging all the countries that are having common law. For instance, you can have US and India and say that better the creditor rights, better will be the effect. But you can't have it in that setup. Why? Because each of these countries in this common law institutional regime will have different sort of institutions. So in other words, what we are saying is that cross-country studies which exploits these bankruptcy laws can't be taken with right rigor. Why? Because there is an average level. So we have to study within the country to know how IBC really fared well. Now, this was the before IPC, more debtor-friendly bankruptcy regime with the DIP process. Liquidation or winding up was used as a last resort. Courts were contributing to delay, and that is still the case. Still, you can see lots of cases being quoted in NCLT. Banks were prime lenders, which has not changed. The bankruptcy laws like SICA facilitated current promoters indulging in forum shopping, corporate finessing, asset stripping, while firms are referred to BIFR. So basically, the previous laws actually facilitated a lot of inordinate delays, and the beneficiaries were mainly promoters or borrowers, not the bankers or the creditors. But there were also green shoots. We had RDDBF Act in 1993, Surface Act 2002, BLRC Commission 2014, and based on BLRC Commission recommendation, we had IPC which got enacted in 2016. So these are the saving features. IPC moves from a deterrent to credit control regime, the restrict timeline, etc. So let me go through the data part. So we used listed companies, and the time period is 2011 to 2019. So pre-IPC period will be 2011 to 2017, 2016, and 2017 to 2019 will be the IPC period. So basically, we classify the years into two, pre-IPC and post-IPC, to know how it works. Now, just if you look at the summary statistics, pre-IPC period, which is from 2011 to 2016, and post-IPC period is 2017 to 19. So you will look at, if you look at the summary statistics, you will see that the average borrowings really came down after the implementation of IPC, which means while 33.4% of the total assets was through borrowings, it really came down to 31%, which is statistically significant, which means IPC, or during the period of IPC, borrowings got reduced. Now, which borrowings? It was mainly secured borrowings. That is why, while the pre-IPC regime, it was 26.2%, it really came down to 22.8% during this IPC period. And the other thing about borrowing is that while unsecured borrowings, which was hovering around 8%, increased to 9%. So what this means is that, just looking at the summary statistics, we can see that during the IPC period, maybe it may not be always related to IPC, but what we can see is that there is a reduction in total borrowing, and in the total borrowing, secured debt actually took a hit, which means during the IPC, people were swapping secured borrowings in favor of unsecured borrowings. Now, what is the problem with secured borrowings? If in a stronger creditor regimes, if secured borrowings are high, and if you empower the creditors, and if you default, secured creditors will come and grab the assets. So debtors will fear that. That's why they are swapping these secured creditors for these costly unsecured borrowings. Now, to do it empirically, we have a model like this where YIP, which is the dependent variable, which is the proxy for the borrowing. So your YIT or the dependent variable are different components of borrowings, and we have a model in which we look at the impact of IPC, which is proxied by IBC, and we also look how firm characteristics coupled with IPC impacts the borrowings. In other words, to put it very simply, we look at how firm characteristics like size, promoter holdings, and tangibility affects the borrowings of Indian corporates after the implementation of IPC. Now, why these three things matters? Size. So some theory says that larger size firms will be more fear of creditor rights because they have more to lose. So if the IPC is having a strong creditor regime, and the creditors will come and grab the assets. So higher the size, what will happen? That is first thing. And second is promoter holdings. What happens when you promote? What happens to those companies which are having higher promoters? Now, why promoters is much more important to say? We can just look at the preamble of Omkar Goswami's report, which says that there are 6 companies, unpaid banks, unpaid workers, there are no 6 promoters. In fact, all those who were beneficiaries during this previous IPC regime was promoters. So in a regime where creditors are strong, what happened to the borrowings of companies which are having higher promoters? That is why the second characteristic is promoter holdings. Third, we also look at tangibility, how higher tangible firms react to the borrowings in a regime of IPC. So you can focus just on this red highlighted part, which says that, so IPC is again the insolvency regime period, increase in size actually during the IPC regime will result in less borrowings. In other words, what we are saying is that firms which are larger in size during the period of IPC will show less dependence on the borrowings. Now, again, which borrowings? Secured borrowings. So what we are saying is that higher size firms or large size firms will be hesitant to borrow by using secured borrowings in the IPC regime. Now, is that a good thing? Certainly not a good thing. Why? Because secured borrowings are less costly when compared to unsecured borrowings. So in this regime, you can also see that unsecured borrowings got increased during this IPC regime, which means firms are actually using more unsecured borrowings rather than going for secured borrowings. So that is the first case. Now, if you look at the second case, second factor, which is promoter percentage, that means higher promoter percentage, how it affects IBC. Again, we will see that secured borrowings actually got declined. In other words, firms which are having higher promoter holdings during this IBC regime actually reduce their secured borrowings, instead increase their unsecured borrowings. So this is the other side of the story, which says that promoters were hesitant to borrow. So now we have two findings. Larger the firms, they borrowed less during the IBC period. Similarly, firms which are having high promoter holdings, they borrowed less during the IBC period. If you look at from the tangibility side, we see that firms which are having higher tangible assets, they also borrowed less, which is indicated by negative and statistically significant sign. So that these three things will tell a story which is coherent in nature, which says that firms responded to IPC in a negative way. They reduced their borrowings. So this is by just looking at the capital structure variables. I also looked at the cost of debt, which is proxied by total interest expenses by debt, which is insignificant, which means impact of IPC may not be that visible in the cost of companies. Now, there are actually problems with my model because it's not a causal model. So in that case, we went for a more robust model, which is what we call as DID model, like average difference in difference model. That means you compare the firms of into two categories, good categories and bad categories, or large categories, small categories, and check how these IPC enacted, or what was the impact of IPC. So we looked at three categories. Again, firms categories as high promoter holding, low promoter holding. That is the first treatment. So how high promoter holding firms vis-a-vis low promoter holdings firms reacted to IPC. High tangible firms reacted with low tangible firms, how they reacted with IPC. Similarly, financial constraints also, we looked how financially constrained firms vis-a-vis unconstrained firms reacted with IPC. Now, let me share the findings quickly. Our findings mainly show that there was no significant impact on promoter holding, whether it is low or high. Similarly, there was no impact on tangibility, whether it was high or low. Similarly, only impact you can see is for financial constraint. That means during the regime of IPC, only unconstrained firms borrowed more. Now that also makes sense because higher quality firms which are having more earnings power, which are having less volatile earnings, that is the proxy for financial unconstrained, they are borrowing more during IPC regime. So in a way, our findings are mixed. So the results from the panelization indicate that after the passage of IPC, proportion of secured debt and long-term debt registered a decline. In contrast, that firms increase the use of unsecured debt. The impact of IPC on the cost of debt is positive, but is statistically significant. So what is the main theory what we are attributing to? The negative association between IPC. That means firms reduce their secured borrowings and long-term borrowings due to IPC is explained by the demand side of creditor rights, which means in India, if you strengthen the creditor rights, it is not the supply side of the creditor rights which is going to work. It is the demand side of the creditor rights which will work, which poses that Indian promoters will forego secured borrowings as they fear the extent of creditor power when creditors are well to protected. Now, this is not in the case of India at all. In 2012, Germany enacted ESUG Act, which is a creditor regime. There were also, when creditors' rights were very strongly, German firms were resistant to borrow by using the debt. Instead, they go for costly equity issues. Why? Because they will not be parting with their assets. So at the same time, we also got some of these, our results are insignificant. So in a different model, we said that no, that is not happening. There is no clear-cut evidence that Indian firms' borrowings got impacted from IBC. So we have mixed findings, which says that there was some effect of IPC, but the IPC's effect on, say, capital structure of Indian firms during this period, like 2017 to 19, was not significant enough. We also have to say that why some of the discussions are insignificant. Now, if you look at during the IPC regime, from the perspective of banks, they are already aging. it is difficult to lend fresh funds due to huge NPA in the balance sheet. So banks are already having, a lot of NPAs. So in that case, even if people attribute to supply side theory, which means creditors will be happy to lend during a strong creditor regime, this will never happen for Indian banks because they are already having stress assets and weak balance sheets. So in such case, banks' priority will be survival and not supplying more and more credit. Similarly, there was promptive corrective action which was working in 2017. So some of these banks may not be able to lend fresh funds because of this PCA regime. And as some of these evidences say, so one of the presenter, Aparna Devi, I have read her one of the articles. She says that there are a lot of cases being proved with NCLT and NCLAT. So even the banks will be reluctant to lend because there is not clear direction where the IPC is proceeding. Now, another side from our own difficulty is that we have only 2-year period, 2017 to 18 and 18 to 19, because due to the COVID time, we could not take 2020 a year because there was a lot of directions given. So we have only 2-year data. So our findings should be bounded by that. And post GST, there were a lot of reductions in the business sentiments. So that is also having an impact on the results. So what we are saying is that given the time frame, our results show that first estimate is that IBC had a certain impact, but that impact was based on demand side. And second says that the impact was not large enough. In other words, the green shoots of IBC are about it. Yeah, that's all from my side. Thank you for giving me this opportunity to present. I am open to questions and suggestions.
Good afternoon. This is Srinivasan Rangan and from IMB.
Yes, sir.
Just a clarificatory question. Your panel,
yes,
I think for your different your panel, was it a balanced panel?
No, sir, it's an unbalanced panel.
Yeah, so if it's unbalanced, it's entirely possible in the post-IBC period, you have new firms entering the panel, which are of a different nature or industry. Right? For example, if you have more tech firms or software firms entering, that may explain why you're getting more switch to unsecured debt. Because generally, banks tend to lend to the brick and mortar firms. So
yes, sir. You're right.
The nature of the SAM, you have to make it a balanced panel. That would be one thing. Second thing, I'm not 100% sure about this, but I think doing these treatment variables, just picking some variable like promoter ownership, that just defeats the point of causal experiments. Right? Causality means you want to have some kind of exogenous division or randomized division between the treatment and the control group. Promoter ownership is an endogenous choice thing. So they self-select into two groups. One is a high promoter and low promoter ownership, and that's not really what the causal literature is about. So you want to think about that in your design.
Okay. So just to answer the first question, in fact, we have controlled for industry effects by looking at the industry level changes. And second thing, we have also, controlled based on the pre-IPC characteristics. So it's not actually, for instance, promoter holdings. We are classifying firms into high promoter holding, low promoter holding, high tangibility, low tangibility, constrained and unconstrained based on free IPC values. So they not co-move with the IPC.
No. That's clever, but it's not. If you look at the time series of ownership over time, last 20 years, promoter ownership has declined a little bit by maybe 1 or 2%. It's very sticky. So the fact that you use the fact that you use a pre-promoter ownership doesn't avoid the endogeneity issue.
Sir, and one more thing, actually, even though I did it empirically, one of the major reasons why I use promoter holdings is that because some of these IPCs laws were explicitly mentioned threatening the promoters. For instance, section 29A, which says that recalculating promoters won't be entered. So I was thinking that if that is the case, good quality firms which are held by promoters, they may not be affected. So let's say promoter holding firms which are unconstrained, they may not be really impacted by IPC, unlike heavily promoter held firms which are constrained. So these firms will be fearful of borrowing because if at all they are not able to meet the requirements, their assets will be taken by. So actually, we had multiple quadrants. So I showed only two major quadrants. It was basically high promoter holding, high quality firms. The proxy for high quality was unconstrained. High promoter holding, low quality firms. How did they react to the IPC's regime? So that was the one of these sub part of our discussion. But yeah, but you're absolutely right that some of these must truly endogenous.
Thanks.
Just one point I want to make. I'm Amit Pradhan here. See,
Yes, sir.
recently we have read that one report, RBI report and economic survey, where it is mentioned that recovery under IBC has been better compared to any other mode which is available. I think you would like to refer to that discussion.
Definitely, sir. No, sir, definitely. So that is true, actually. I mean, I'm not saying, for instance, some of the results are actually showing that IBC is a better regime than even SARFAESI and PIA. But I do agree with that. And there are, of course, my problems with my own design. So I'm not saying that this very defeats the purpose of IBC. Based on my sample, within these limitations, I could provide only little results. That's only I'm saying. I'm not saying IBC was ineffective. Sorry if my presentation was in that term. Sorry.
Thanks.
Yeah.
Please,
Actually, your findings state that the unsecured creditors and the short-term creditors have increased, right? So can you hear me?
Yeah, true. Yes, sir. I'm able to hear me now. Yeah.
Though you are bringing up the impact of IPC, production of the IPC, but would you consider the secondary market available for these corporate bonds, like how now RBI is contemplating on bringing up the secondary market for NPS? Again, the CRA rating for the short-term securities, though they are unsecured because of the rating available, if the company is really good, they are able to get the funding. Will you include those variables also?
No, ma'am, definitely not. That is a good thing. In fact, the use of classification of borrowings was based on existing literature that how secured credit, debt and unsecured credit gets impacted by this credit. So I actually used that mode only. But yeah, I mean, I was not knowing that there are ratings for some of these, even for the short-term securities. Yeah, that's great. Yeah, I'm happy that for that suggestion. So that's good. That's good. I have not thought about it. Thank you very much for suggestion.
Thank you, sir, for the wonderful presentation. Now we'll move on to next presentation.
Okay, thank you very much for the suggestions. Thank you. Yeah.
So our next presentation is by Mr. Pranay Agrawal, who is a student at Gujarat National Law University, Gandhinagar, and his paper is titled Cross-Border Insolvency Law and Challenges in Adopting Unicycle Model in India, a Critical Analysis.
A very good evening to respected panelists that are present here and all the other legal luminaries in this field. So my name is N001. This is Pranay Agrawal. Our paper essentially talks about cross-border insolvency law and the challenges in adopting the UN model in India. So we presented a critical analysis on this paper.
So as we all know that globalization has been a part of the world since 1991 and India has been greatly affected by it. There are like many MNC that has been like established in India and various Indian MNCs also that are working very well in various other states. So there are high number of creditors, debtors and various other stakeholders and investors that are dispersed around the various parts of the world, and that makes the cross-border insolvency very important in today's world. So what the UN settlement model is, before that we had to understand what are the approaches or the philosophies that are related with the model law or the cross-border insolvency. So the first is the territorialism. So for that we can assume that there are two countries, A and B. For that we can also assume that in the pre-model law world, where the model law was not there, in Japan, which was very territorial in nature, was had a company, that Panasonic, that is still operating in India as a foreign company. So if the Panasonic is operating in India as a foreign company, as various operations as a manufacturing unit in India, so what is happening is, in India, if there are various creditors, like suppose there are banks and various large creditors, small creditors, and even the investors have been financing that company for its manufacturing unit, then if in case of the insolvency, what will happen, that the insolvency proceedings will be happen in Japan with the Japanese laws and insolvency laws, which although may be very much effective in case of that scenario. However, Indian courts will not be giving that effect on that Japanese law and order. So there will be a little confusion, chaos in the investment market and also the commercial markets of India. So because of that, the territorialism was a little criticized by various scholars and various commercialists. So also after the development of international law, that is began after the decline of the positivist and the coming of the international law as a new approach by the Oppenheim, then what happened is universalism was adopted as one law and single judicial forum, and idea of a single uniform law was given. However, for that treaty and convention had to be signed, and countries were a little reluctant to sign these treaties due to surrendering of sovereignty and jurisdiction issues. So the UN settlement model, or we can call the modified UN, provides a middle path to that scenario.
Just going back a little bit. So another aspect which I feel is that a famous quote is that we must let go of the past, but we must learn from it as well. So before we move on to future developments and how exactly we can incorporate the UN settlement model and cross-border insolvency in India, I think it's also important that we revisit the past and understand what exactly went wrong, and in particular the two reports by the Eradi Committee in 1999 and the NL Mitra Advisory Group Committee Report 2001, I think is very important in this regard for understanding what the particular issues in our Indian cross-border insolvency framework are and how exactly we can overcome them. So briefly going up on the Eradi Committee report of 1999, what essentially the Eradi Committee report talked about is that we could have an input-output mechanism along with coordination proceedings taking place in foreign jurisdiction. So if we look at this, this is similar to what is being envisaged under the Insolvency and Bankruptcy Code of 2016. So at the moment, as we know, there's Section 234 and Section 235, which talks about reciprocity agreements under the Insolvency and Bankruptcy Code. Now, interestingly, what has happened is that although this might sound good in theory, this hasn't been the case so in practice. At present, India does not have reciprocity agreements concerning cross-border insolvency issues with any other jurisdiction in the world. So we have to understand that why exactly has this particular framework failed in that regard. So we'll be touching that upon in the following slides. Now, particularly the report of NL Mitra in 2001 also is important, as it mentions that the cross-border insolvency framework in India, it talks about the separate proceedings being in the Indian domain. This was inspired by English law. Now, because of this, Indian law did not have its own foothold with regards to cross-border insolvency framework, particularly when it comes to the CPC. So in the CPC right now, we do not have a specific provision which recognizes foreign proceedings. As a result of this, a large part of proceedings which take place abroad, there's a huge isolationist perspective that is created with regards to what is being practiced in India and what is being the international standard that is taking place. As a result of this, it is difficult for India to kind of correlate with what has been happening across the world. Now, moving towards our current policy regime, as I've already mentioned, that there's a lack of comprehensive framework regarding Section 234 and 235. Even though the IBC has given us the basic idea that we can enter into reciprocity agreements, it hasn't exactly told us what specificity we should include in this reciprocity agreements. That has been left to us, but there has not been much work which has been done in that regard. And I think that is one major defect in our current regime. Now coming towards draft part Z, so the ILC report in 2018 by the Insolvency Law Commission, that was particularly championed to incorporate draft part Z, which championed the idea of having the UN civil model law in India. Now, when talking about draft part Z, they talked about 4 main points. So they talked about 4 main points, wherein they idealized that since the UN civil model law has been adopted in more than 50 jurisdictions, it would allow us to kind of become a part of the international family and help bring India, this insolvency framework, onto the international level. However, there are also certain problems within the draft part Z, which I think hasn't been addressed by the ILC, but which we'd like to point out here. So, firstly is the idea of pre-initiation exclusion. So what draft part Z has done is that it has categorically excluded NBFCs and a large part of infrastructure services when talking about adopting this model law. So what this essentially does is, since this is such a critical infrastructure sector for India, if we were to exclude such a large part of them from availing the benefits of a model law and cross-border insolvency proceedings in the international setting, I think that would be a very big drawback for the Indian insolvency regime. Secondly, coming to the idea of corporate debtor and foreign company. So the IBC expressly does not define foreign company, but rather uses the Companies Act as an ouster to define what foreign company is. And it has been mentioned that foreign companies in India at the moment, cross-border insolvency proceedings can only take place against corporate debtors. Now, because of this issue of foreign company and the definition, oftentimes what happens is a large part of domestic creditors have been left behind. Thirdly, coming to the concept of establishment, which comes under clause 2C. So, I think yesterday's keynote speech as well, we had heard about the idea of, for example, the FTX crash which happened. And with the rising digital age, we know that there are concepts wherein there are a lot of e-commerce companies and internet-based companies which are coming into the fray. Now, what happens is that this definition of establishment under clause 2C of the model law uses the word with human means. What this essentially means is that it disregards companies which work in an electronic environment or in an environment which is strictly internet-based. So how exactly the liability of e-commerce companies or companies which do not have a physical base in India would function is something that I believe the IBC and the IBBI should take into account when defining the word, when defining the clause establishment and when we do take it into adoption. Coming to the 4th point, which is public policy exception. Now, Article 6 of the UN Citral Model Law essentially talks about the fact that a country can be allowed to not accept a foreign proceeding if it is against its own public policies. Especially the word manifestly has been used under this article, which is in a narrow sense, and I feel India as well should not include this particular word. As being a very culturally diverse country, we should have the ability to decide if we were to incorporate foreign main proceedings or not based on this public policy. Finally is the right to access, which I feel is the final important point. Under Article 9, essentially what it says is that every foreign creditor and foreign representative which would like to take legal action in India, as per the model law, they can directly approach courts in that particular country. Now, as we know, in India, foreign lawyers are not allowed to practice, and what we follow is a representative system. And it is a common understanding that our judiciary is burdened. So what happens when foreign representatives, if we were to adopt this model law, are given a direct right to enter into our country and access our legal courts? This separate system of foreign representatives and how exactly their legal representation would take place in the Indian insolvency framework, I feel is another point which has been left out in draft part Z, and the committee has not exactly elaborated on what exactly we could do with regards to that. Yeah, and finally, I'd like to talk about a little bit about the hindrances with regard to the adoption of reciprocity agreements. So, with regards to UN settled model law, although it has been adopted by a wide range of jurisdictions, it does not have universal adoption. There are still certain countries which have not adopted the model law, particularly, for example, Germany and Japan. These are also economic heavyweights which have a lot of trade ties with India. So how exactly we would be going about that in the absence of UN settled model law being applicable? Would we be going through with reciprocity agreements? And if we were going ahead with reciprocity agreements, would we be following the old Section 234 and Section 235 IBC agreement? I believe that is something which we should not be following. Now, why is this? Firstly, because there is no incentive for these countries to enter into reciprocity agreements. Largely what has happened is that India has also followed a territorial approach. Because of this, a lot of the times when there has been consideration for a reciprocity agreement, it has been very India specific, and rightly so. However, when we come to a cost-benefit analysis and we look at into why parties enter into an agreement in the first place, there is a lot of bargain, there is a lot of room for negotiation. And that is something which has so far not been done. And I feel this hyper nature of India centrism could, in the long run, affect our economic impacts, and it could affect our investment in India in itself. So I feel when it comes to reciprocity agreements, we would rather have to take a more equanimous approach in understanding how exactly we will deal with these non-UN settled model adoptive nations. The final point that I'd like to talk about is the lack of clarity with regards to the civil procedure code. Right now, with the recognition of foreign main proceedings, as well as Section 13 and Section 44A, the clauses in our present jurisdiction are not enough and they're not clear. Even Section 234 and Section 235 do not present us a clear and cogent mechanism as to how we'll enforce these reciprocity agreements. These are all reasons for why other nations have not entered into reciprocity agreements with India. And I believe if we can work on these, then definitely we can improve our cross-border insolvency framework, even with nations that haven't particularly adopted the UN settled model law.
So regarding the reciprocity agreement only, there are various countries and MNCs which are operating in India, and also the Indian MNCs which are operating elsewhere, like as Ayan said, Germany and Netherlands and China. These countries are like various like commercial hubs where the Indian MNCs are making a lot of more profits. So in this regard, we can just say like not every country will be adopting the model law, right? So what is happening is the model law has been adopted only by some of the countries like USA, UK and like Singapore like countries, but not all countries like Germany and Netherlands, which are also the important investors in India. So in this regard, we can just classify these countries in the model law nations and the non-model law nations. So what is happening is the model law nations which have adopted the model law has a fixed or a uniform regime or insolvency regime for cross-border insolvency. However, those who have not adopted the model law, India has to rely upon the cross-reciprocity agreements and other contracts so that they can resolve the cross-border insolvencies in these areas. So if there are reciprocities in these areas also, the reciprocity will also depend on the rigidity and the nature of that country's law. And therefore, a differential treatment can arise. One can take an example of a company in Germany where there is a little flexible law and the people will like to invest there because the creditors will make themselves more secure in Germany. However, in like countries like China, where Chinese creditors are given more rights, they might be like less secure in investing there. So if you see here, like India's main commercial partners has been classified, has been taken in the present paper is Germany, Netherlands, Taiwan, China, where India has one of the most business in the world. So if you see in Germany has adopted a universal approach and has like debtor-centric approach. So India can think of agreeing with a reciprocity with Germany. In Netherlands also, as we can see in the latest Jet Airways case, India will be thinking of having a reciprocity agreement with Netherlands also. However, the law is totally different with the Netherlands, and there is no affinity with the Indian law or the IBC. Moreover, as was also held in the Yukos oil case between Russia and Netherlands, there is a territorial approach has been followed. In Taiwan also, if we see, the affinity is comparatively more than the Netherlands. However, a territorial approach has been followed and has been said in China also, the Chinese creditors are being given more rights, so Indian creditors might be less secure. So in this sense, what India's stance will be a little different while adopting a law, and therefore various things have to be looked upon while agreeing in reciprocity. That can be the nature of the law of the country, the commercial impact that can have on that country, and that the transaction value that has in the country, and also the political and other economical nature things. Not only that, also the legal framework that has been implemented in that country for resolving such insolvencies or the creditor welfare approach is also very important. Lastly, in this paper, like we had a comparative analysis with 3 jurisdictions of US, Singapore, and Japan, which had adopted a model law. However, we have done the research for understanding that how harmonization is very important. As we can see in USA, Chapter 15, as all of us know, that Chapter 15 of the Bankruptcy Code has made the approach from territorial to unified universal. However, a narrow interpretation has been given center of main interest, where even the headquarters of the company can be called as center of main interest. In Singapore also, we can say that the Singapore characters are given much more value than the other characters to make the laws in favor of the creditor-centric approach, or the creditor-first approach has been there in Singapore since centuries. Also in Japan, has been referred before, the creditor-centric approach has been the main idea, and also if we see in the Japanese experience, the role of the courts has been much larger because of the fact that the Japanese courts have done a lot of much work before the implementation of the model law, so that there is a little flexibility in the law beforehand, so that there is a successful implementation of the law in that country where the territorial approach was much better. So if we see that in the conclusion we can say that the harmony is very necessary, harmony and the reciprocity is very necessary for model law, which will be implemented in India in some other time. However, some changes have to be made in the law so that a successful implementation has to be taken place. In this regard, the recommendation can be that the legislative reciprocity should be adopted. In this regard, the legislative reciprocity can be defined as the reciprocity with only those countries which has the regime which is more suitable for the Indian creditors and the Indian companies. So that will solve many of the problems. Also, as been already stated, that the harmony is the key to the successful implementation of legal transplantation, and so the US return model has to be implemented with the harmonization with respect to the insolvency regime in India.
Also, I believe it was the IBBI chairman yesterday, if I'm not wrong, who also talked about the idea that the UN Citral model and its adoption is a definite understanding. It is going to take place. However, when we look at countries, for example, such as Singapore, they have effectively modified the UN Citral model law in a way that particularly suits their jurisdiction, and at times it's even questionable as to is this what the model law is about. So with regards to that, I believe there are certain policy recommendations which we should also take into place when we are adopting the model law, which is a truth. So firstly, as I've mentioned earlier, the modification of the concept of the term establishment. In the current digital age which we are living in, I believe if we were to include the word which is with human means that comes under this particular article, then we would be excluding a large set of internet-based companies and electronic entities which are the norm of the world at the moment. And if we were to exclude this, then this would in the future be highly detrimental to cross-border insolvency proceedings which can take place in companies such as this. Secondly, the public policy issues regarding Article 6, again the use of the word manifestly has been used in a very narrow sense, and I believe India can do away with this particular word in order to ensure that we have our courts have a higher jurisdictional power when it comes to deciding cases in this regard. And finally, the representation to foreign representatives. As I have mentioned earlier, the model law allows for direct representation to foreign representatives. However, in a country such as India, with our jurisdictional setup and our jurisprudence, I believe it will be highly difficult for foreign representatives to have direct representation through their legal counsel. Rather, we could have a setup wherein there are Indian representatives, which currently takes place, and through Indian legal channels, these foreign representatives can gain representation. So I think, yeah, that concludes our presentation. Thank you so much for your time, and we are open to questions.
Thank you. If anyone has any questions.
Yesterday you heard about the jail guidelines and inter-court talking and agreements can work.
Yes, if I've got your question right, I think you're asking us when there's a talking between courts, right, how exactly that would help us. So I think when it comes to cross-border in the cross-border insolvency framework in India as well in that regard, I think what we're trying to do with the adoption of the UN Settled Model Law is also that by entering into this club where there are already 54 jurisdictions, it would certainly allow for a transfer of information among courts. And I believe if we were to adopt this with the modifications that we have suggested, it would definitely open up the door to have conversations among jurisdictions, and it would allow us to benefit from what these jurisdictions have been following. For example, the Singaporean jurisdiction is comparatively evolved in this insolvency setup, so we could definitely take ideas and understanding from them as well, I believe.
Yeah, thank you so much for your presentation and highlighting an important point of cross-border insolvency laws. We look forward to the next presentation now, which will be the last presentation of the session. So I would like to invite Mr. Vishal Dave, who is practicing advocate at Gujarat High Court and various High Courts, Tribunals and Supreme Court. His paper is titled as RERA versus IBC, Landowners, Developers, Builders, Allottees as at Crossroads. So thank you.
Very good evening. So this is our last presentation. As far as my topic is divided into three parts. First, I will deal with the interplay between the real estate law, that is the RERA. Am I audible now? Audible now? Is it audible? Hello. Yes, now it is audible. Right. So this presentation is divided into three parts. First, I will deal with the interplay between the RERA law and the IBC, how the involvement of the enactment of the RERA into the IBC regime. Second part of the presentation will deal the impact of the real estate project in the CIRP process. That will be dealt by my colleague Mayur. And the third part would be the impact of the joint development agreement between the landowners and the developers under the CIRP. What will be the impact of such agreements? That will deal by my colleague Sejal. So as we know that prior to enactment of RERA law, that is a Real Estate Regulation and Development Act 2016, the real estate is totally unorganized. So to organize in a proper way, this law came into force. Now, real estate has gone major changes in this growing years with the impact of GST, with enactment of RERA, and then IBC. So now there has been a very critical issues between the implementation of the RERA law as far as the real estate project is concerned, and the companies and the real estate companies who go under the CIRP process, or once the CIRP starts, then what would be the fate of the real estate projects? Because real estate projects has, if you see the RERA law, there are three major stakeholders. One is the allottees, that in the generalized term we call home buyers, who buy the flat or their unit in a real estate project. Second, the stakeholders is the developer, who develops the project, and third is the landowner, right? So these three are the major stakeholders. The most impact which the home buyers had prior to the companies who goes into the CIRP is the home buyers, because initially there was no definition or any kind of protection for the home buyers when the companies or the real estate companies who go into the CIRP. So now the first law or the recognition of home buyers and the transaction between the promoters and the home buyers recognized in the case of Nikhil Mehta, wherein the enclad held that the buying of a property for a sum of assured return, so this agreement of selling of the property and buying of the property was recognized as a financial transaction, and this transaction was defined as a loan. And this is how this was the first instance wherein this real estate transaction between a buyer and the seller was recognized as a financial debt, and this is how the law developed. Thereafter, the second amendment came, and the two explanation was inserted in the section 5, wherein if you see this is a judgment of Pioneer Supreme Court, where the harmonious interpretation between the RERA and the IBC has been considered by the Supreme Court, where if there is any conflict, IBC law will prevail over the RERA law. So the IBC will have the upper hand compared to the enactment of the RERA. So this was the constitutional validity which was challenged, and thereafter, next slide. So now, since the first process where the home buyers started getting recognition, because this was a very larger issue here in India, because home buyers, especially in the residential projects, has a huge impact over the economy. So this is the second amendment ordinance came, wherein the explanation was inserted. Now this explanation is very important. Any amount raised from an LOT under a real estate project shall be deemed to be an amount having commercial effect of a borrowing. The expressions LOTs and real estate projects shall have the meaning respectively assigned to them in clause D, clause ZN of section 2F of the RERA Act. So kindly see, because of this explanation, the definition under the RERA Act, the definition of a LOT and the real estate projects and the transaction has been explained in this section. So now, whoever are the LOTs under the real estate projects are recognized under the IBC as a financial creditors, and now they have a say and they have a right during the CIRP process. Now, because this category came because of the judicial precedent, thereafter the law recognized by way of an amendment. So now for every home buyers who has to lodge their claim, once the company, real estate company going to CIRP, there they have to have a form FA. So now the regulation has also created a separate category for the home buyers who has to file a form FA for the claim against the company for their sale transactions. Thereafter, now earlier what used to happen that even a single home buyer who has a financial debt can file section 7 application and take entire real estate company into CIRP. So there was not any threshold. So single buyer can also take, because what used to happen earlier is that there was a litigation before the RERA authority between the LOTs and the promoters. So there used to be many LOTs in numbers. So to pressurize, if some LOTs who are not satisfied with the RERA proceedings, a single home buyer can file a section 7 and he can trigger CIRP. So from the mechanism of the RERA proceedings, the entire shift is over to the IBC. So to tackle this situation, now the amendment has come and the threshold has been prescribed. So out of the total number of home buyers, 10% of the total number of buyers can initiate section 7, or the total numbers can file section 7. So this threshold is very important, because so that a single home buyer cannot file section 7 and entire company cannot go into the CIRP. So this is, we saw how the law, because IBC and RERA both are evolving jurisprudence. So as soon as the nature of transaction, the complexity will come, the law, the precedent will take its due course. Now if we see the categories of LOTs, so there are different number of transactions between an LOT and a developer. So if we see the home buyers category, these are the interpretations which we have correlated. First is the LOT seeking refund and cancellation. So there may be a home buyers who have booked a flat, but after, because of delay in possession or they are not happy with the progress of the project, they may withdraw from that project. So they may cancel their booking amount. So seeking and refund, so they have to seek refund for whatever amount they have deposited. So this transaction also comes under the purview of the RERA Act. So they are also one of the allottees. Application money given but no allotment letter is given. So in some transactions what happens, a home buyer booked a flat, but the promoter or the developer has not issued any allotment letter. The another nature of transaction is allotment letter is given but no possession is given, because of this recent development in the GST, IBC, RERA, it has led to a huge impact in completion of a real estate projects. So now, prior to the delivery time for any project is to from 1 to 1.5 years. Now, because of this pandemic and for other factors, the possession has been delayed. Even under the RERA, because of this corona, they have given the for a completion of project, they have also given time limit extension so that the project can be completed. And allotment done, possession not given, but no registration of that. So registration of project is now, it is very important under the RERA law. So for any new project who comes where the RERA law is applicable, under section 4 the registration is mandatory. Without registration the project cannot start, because now they have to have a designated RERA account where the money which comes from the allottee, 70% can be used, and for that there are all compliances, CA certificate, structural engineer certificate, and all these compliances are there for a project, so that the money is safeguarded of the allottee. So these are the broad categories of transactions where the allottees come into picture. Now, as far as we have seen the categories, now for recognition of an allottee, the nature of transaction under the, because it's a privity of contract between a developer and a home buyer. So the nature of transaction, the clause of the agreement is very important. So one such transaction could be a buyback agreement. Buyback agreement wherein the promoter promises that after 2 years or 3 years, he will buy back the same unit at the assured return. So this is a buyback agreement. Now this type of transaction is also recognized in the case of HT Media Limited. So buyback is one of the nature of transaction in the commercial real estate projects. Another type of transaction is assured returns. So whenever an allottee invests in a project, the builder promises assured returns for the money invested. Now this type of is one type of a borrowing which the developers now try to create from a market where they don't have to offer any security. So it is a one kind of a recognized borrowing which they get at a very low rate of interest. Though it is not regulated, but main benefit to a promoter is that he has to don't give any security. So in that he promises some assured returns. So normally an investors who buy some chunk of the units in a project and they get some assured returns at the delivery of a project. So these are the assured returns. So this all things depends upon the clause of the agreement. So this is type of transaction is also recognized in the case of Nikhil Mehta. Now, what is the treatment of the home buyers? So now the law says that home buyers are not well educated. Sometimes what happens once the CRP is initiated, publication is done in the newspapers, so they have to give claims within a period of 90 days. This is the law which mandates. But since the allottees are not that much educated, so the duty of the IP is that he has all the claims which comes related also, he has to correlate it and he has to collect all the claims so that no home buyers get prejudiced because of he has no knowledge about the entire CRP process. So that treatment is very important. Home buyers cannot invoke RERA decrees. So now the object of IBC, as we all know, is the resolution of company, not the recovery. Therefore, whatever the RERA decree is passed under the RERA proceedings, where it is in nature of a money decree which we normally execute under the CPC before the execution court. Even the RERA has power to pass a decree, and as per the land revenue code, they recover the money. So such mechanism is not recognized under the IPC. So any home buyer who may have a decree in his favor cannot initiate CIRP under the IBC for the purpose of recovery. So that is one of the aspect. Another aspect is a representative, authorized representative. As we know that the home buyers play a huge impact, being a financial creditor, as they sit in the CRP, in the COC committee, they may influence the decision making of like approval of the plan and the rejection of plan. So the voting percentage sometimes becomes very important. So now, but to represent, there may be 100,000 home buyers, as we know. So now the concept of authorized representative has come into play, wherein for a set of home buyers, they appoint some authorized representative who will take a decision, who will attend the COC meeting, and we have a right of voting, and this is how the proper representation of home buyers will be recognized. So this was my topic. Next topic will be taken by you.
Hello. Yes, I'll finish it off. My topic is small, but it's a developing one, so we'll finish it off. So my topic is project-wise CIRP. So basically, project-wise CIRP was first introduced in flat buyers case. And it was firstly applicable in the case of Supertech, wherein it was decided that since a corporate debtor has multiple projects, but since because of default in one project, the other projects cannot go into the rigors of CIRP. So wherein in this Supertech's project case, the court decided that there should be a separate Form G or a separate expression of interest for the resolution applicants to offer for completion of the project. And why this project-wise CLP was firstly introduced, because home buyers are basically interested in their money, so they have monetary needs and they have a pecuniary interest in the flats or the project. So what court took a cognizance of this matter by stating that since this home buyers should not go by the process of CIRP, which is expression of interest, resolution plans, approval of resolutions plans, and approval of resolutions by authorities. It's a long process, it's a time consuming process, and these home buyers have taken loans from the banks. So to balance or to strike a balance between all this together, there should be a project-wise CIRP. So project-wise CIRP will take care of the interest of secured creditor who has given the loan to the corporate debtor. It will take care of the interest of the home buyers who want their homes to be completed or constructions to be completed, and also the interest of the banks who have given loans to those home buyers. Also, it helps in keeping the corporate as a company as a going concerns. Now, since there were certain reasons for bringing a specific project-wise CIRP and the reversal of CIRP, there is also one more reason to that effect, that the home buyers cannot afford a haircut for the home buyers are huge if it is said that they participate in the CIRP. The decision-making power of the home buyers is considered to be dependent on the authorized representative, and authorized representatives do not have any voting rights in the CIRP. So technically, home buyers do not have knowledge of the CIRP. So in many matters now, courts have taken the cognizance of this project-wise CIRP and considered this process to be more effective. So therefore, since courts have taken cognizance, the law should also take cognizance of this practice and should bring some regulations with respect to this project-wise CIRP and bring regulations to that effect. Now, the regulations which requires consideration is the duties and responsibilities of RP in project-wise CIRP. So RP should be given a power to execute sale agreements, and they should be given power to sign a counter sign on the sale agreement, so that the homes or the flats could be given to the home buyers as a benefit to the home buyers. also the RP should be given powers to draw amount as per the RERA laws, and therefore they must be given a way out in the RERA laws also, because both the laws have to be harmoniously constructed so that this project gets completed quickly. So now the landowners and developers issue will be dealt with.
Good afternoon to all. Joint development agreements. Joint development agreements are quite common in Indian reality sector, wherein the landowner provides its land and the developer develops the property. However, in case of joint development agreement, there is no transfer of title that takes place, and the legal ownership of the land remains with the landowner himself. In such a case, when there are two separate entities, that is the landowner and the developer, and the ownership of the land the legal ownership is with one of the entity, and the other entity has only the development rights. In such a case, if the CIRP is initiated against either the developer or the landowner company, then there can be several issues. Suppose if CIRP is initiated against the developer company, then in that case, the landowner company may consider terminating the joint development agreement and bring back the possession of the land in its own company. If this happens, then there will be nothing in the hand of the developer company which can be revived. Such a scenario was faced in a recent issue, which was a recent case before Honorable Supreme Court in the matter of Rajendra Kumar Bhutta versus Maharashtra Housing and Area Development Authority. In this particular case, the question before the Honorable Supreme Court was whether a land in which the corporate debtor has development rights in its favor pursuant to development agreement can be treated as an asset of corporate debtor. In this particular case, the Honorable Supreme Court held that because of the moratorium under Section 14(1)(d), the landowner do not have the right to take back the possession of the land because of the joint development agreement. Another question is that whether joint CIRP of the developer and the landowner company is possible or not. Because the land is belonging to the landowner company, and if CIRP is initiated against the developer company, to bring the land into the CIRP of the developer company, is it possible to do joint CIRP of both the developer and the landowner company? In IBC, there is no provision to do joint CIRP of landowner and developer company. However, there are a few of the judgments of NCLAT where they have allowed the joint CIRP of the companies. However, such joint CIRP will be detrimental to those landowner company which are otherwise financially very sound. Because if the CIRP is initiated against the developer company, just because of that, a landowner company which is financially very sound will be dragged into CIRP. So this will be so there should be a proper provision wherein joint CIRP of the landowner and developer company is provided, but those companies which are financially sound should not be brought into CIRP, and a provision should also be made that all the assets of the landowner company should not come into CIRP, but only the land which is in question should come in joint CIRP process. Since the time is up, so I am concluding here itself. Thank you so much.
Thank you so much for the wonderful presentation. Now I would like to open the floor for questions, if any.
So normally when we get a real estate CIRP, how role is restricted to intimating RERA that the company has gone into CIP. Do I run it as a going concern? So what are the RP's duties towards RERA?
Right now there is no mechanism, but it is the duty of the RP if a company goes into CRP, because there may be a RERA proceedings against maybe going on with that certain project. So it is the duty of RP to intimate it.
We just intimated, that's our.
Because as soon as the moratorium comes into play, the whatever the proceedings there before the RERA will come to an hold. So because normally what happens is that since the RERA authority is not intimated, they go on passing the orders of the decrease and everything.
In the recent document which our regulator has given, we have made a suggestion that the RP should also be allowed to sell the unsold areas. Now in that situation, what will be the RP's position?
Yes, in that situations, in one of the matters in peace infrastructures, RP has been allowed by the court to even sign the sale agreements on behalf of as a counter signature.
Pre-sold.
Yes.
I have recommended and suggested to the regulator that RP be allowed to sell the unsold area also to run the project.
Yes, that order is also there. There is a situation where there are unsecured creditors and secured creditors, and because those properties are not executed properly, those creditors becomes unsecured creditors. And in that situation, also in peace infrastructure case, which I am referring to, the courts have allowed RP to execute and sell those unsold properties as well. So this is developing. This is coming and on. No, it is not so. The pioneer judgment is very clear that RERA and IBC will go hand in hand. Hand in hand, it will go.
But whatever is the order given by the Insolvency Court is to be implemented, and all RERA proceedings will be squashed.
Yes, that is there. That is there.
So that means that it is a superior
Section 14.
No, it's not superior. It will go hand in hand, and the law is made in that way that. The major reason behind this is that most of the RERAs is also not organized, so they do not understand IBC. That is one of the.
What happens in JDs is that as per the RERA, precisely it says that the landowner is a promoter. That's clearly brought up. Whereas in the NCLAT, there's a problem. You know, that is where the court orders and everything has to come where the landowner is not part of the whole proceeding. And there are two companies that are fighting it out, and two companies cannot go there. So one of the mechanisms that we had already suggested way back to the RERA itself was when you have JDs or JMDs, you put it out as an SPV. That becomes a proper channel to then initiate arbitration or even bankruptcy. Right? Then somebody else can take over. That can be pushed back to RERA. Why does, and as you rightly said, should go hand in hand. Why does the bankruptcy insolvency court need to take everything to them? We can push it back to RERA there and say, find somebody else to develop this whole problem. Right? So that can be a solution. If you are looking for solutions or rather.
In fact, this lady, we have raised the MADA issue. Smart builders get a power of attorney into the tripartite agreement. BBA का MADA, builder and the buyer. So it is the JDA. You take a power of attorney from MADA and somebody signs them on behalf of MADA as a tripartite.
This developer issue, you said their insolvency should not affect the landowner company. So what happens? This landowner company generally floats a subsidiary, but they are themselves the owner only. They are controlling, and they just want to avoid this insolvency things. I am facing that issue personally because one subsidiary which is a developer, and that the landowner company is very sound. Developer may not be sound because they have some limited role. And moreover, they are agent of the landowner company only. Why should we separate them? It's a good ruling, I think.
That's the ruling of MCLAT also, yes.
But you don't want this ruling, na?
We want it, but we are just suggesting that it should not happen with in all the cases, because we were suggesting that only the asset or the land in question should be brought into CIRP. Otherwise,
I got your point. As a home buyer, when you go to buy a flat, you are not aware of this tripartite agreement. You just see the face of the builder, see override. But when you sign the agreement, you sign override some reality, something. So that override main owner, they just want to avoid this IBC things. It's a very good ruling, I think.
And in case if the joint agreement is in form of partnership, there is a society which has formed an agreement in form of with a partnership firm, and then the corporate debtor enters a partner and another partner moves away or the share is taken away. How will a partnership firm come in CIRP?
yes, that was also one of the issue that we had mentioned, that it is not possible for a partnership firm or an individual, how they would come into CIRP was one of the issue that I was going to mention, but because of the time I couldn't take up the topic.
Different remedies that can be taken but not under IB code. There are partnership firms or landowners are individuals. So that there the different remedies are there but not under IB code.
See, the influx of huge number of real estate cases into IBC isn't the reason of that RERA decrease. That there is no other way for promoter to escape from RERA decrease than to come under Insolvency and Bankruptcy code. So what is the problem of RERA is being pushed into IBC. Rather, it should be taken care in RERA and it would be a better solution. Maybe if the learned speakers could help me on that.
Now actually RERA mechanism also are more effective because now they are passing civil prison orders against the developers or not implementing. But that in the real estate scenario, what is the problem is, starting from the sanctioning of the plan, the title, the possession, they have n number of agreements who are drafted. There is no specimen to it because the rights are distributed totally unevenly. So this issue will always come in the RERA proceedings also, the interpretation of the privity of contract comes. So these are the issues unless there has been now there is a specimen of a draft which is under the RERA Act. So unless these are modelized, this transaction under the IBC and the RERA, these challenges will still be there, and it has lost to as soon as the real, because now organizing the real estate sector, implementing, because in Gujarat we are implementation under the TP scheme only. Beyond the other areas are not there. So now unless the implementation becomes more effective, more organized way, the IBC regime will again have the impact over the RERA real estate projects.
Second, land is a state subject.
I can stop over here.